of this matter, Lordship has fixed this matter. I supposed to do this matter, but my learned friend, my Lord, Mr. Loskor's mother expired, my Lord. I need to attend this funeral ceremony. I have taken consent of the other side. Can it be on, my Lord, on this 27th or 3rd of June, my Lord? 27th of June?
Can we?
27th.
Learned Counsel Mr. P.K. Deka with the consent of the other side has prayed for adjournment. Please the matter on
Blessed.
19, no?
May it please your lordship, I beg to mention item number 3. Lordship, with the consent of the appellants, lordship may kindly be pleased to pass over the matter for the day. Lordship, if it can be fixed on 26th May, my lord.
You have taken consent from the other side. Pass over for the day.
If it can be fixed on 26th May, my lord.
Learned, what is your name?
D. Rathi.
Learned Counsel Mr. D. Rathi with the consent of the other side has prayed for adjournment. Is the matter on 26 May?
26th May.
Okay. Interim order shall remain in force till then.
Lordship, in respect to item number 12, with the consent of the respondent, lordship may kindly be pleased to adjourn the matter for the day, and first any date may be fixed in the first week of June, my lord.
Okay, now, item number 12. 5th of June.
Much okay.
Item number 12.
Well,
আগৰ কি আছিলে প্ৰথম
May I please, your lord?
Yes, yes.
My lord, and for item number 18, my lord, this we have taken consent from other side.
18-1-8.
18-1-8,
So there's some urgency, but can you not 29th, madam?
or 29,
29th.
Learned Counsel Mr.
SR Borwe.
S.R. Borvia with the consent of the other side has paid for adjournment, list the matter on 29.
Madam, madam.
Yes, please, your lordship. My lord, item number 7, my lord. With the consent of the other side, my lord. For 1 week time, my lord.
1 week time.
1 week.
Learned Counsel Mr.
MJ Kadir, my
M.J.
Kadir.
Adi with the consent of the oh, yes, yes.
No.
I got your name.
Yes.
It's in the 3rd. With the consent of the other side has prayed for adjournment, list the matter on
After 1 week, my lord, on
1
22nd,
week.
after 1 week. Public.
May it please your lordship. With the consent of the other side, I beg to mention item number 24, your lordship. In this matter, we have appeared for the first time today, your lordship. That's why I'm seeking some time in this matter. Can it be on 9th of June, your lordship?
I am appearing on this matter, your lordship. A date may be fixed, your lordship.
9th of June, your lordship.
10.
Public.
The may it please your
Learned
lordship.
Counsel, what is your name?
J. Das,
J. Das. On behalf of
the senior counsel, Mr. Bhaskar Datta, your lordship.
Learned
Respondents.
Learned Senior Advocate Mr. B. Dutta with the consent of the other side has prayed for adjournment, list the matter on
Deeply obliged.
for the respondents.
May I please, your lordship? Well, with due consent of the other side, I beg to mention item number 14. Well, this matter may be taken up, my lord, on my lord, 29 June, my lord.
Learned Counsel Mr.
M. Islam, my lord.
Learned Counsel Mr. M. Islam for the respondent number 1, 2, and 3 with the consent of the other side has prayed for adjournment. This is the matter
My
on
lord, on 5th June, my lord.
5th June.
5th June, my lord. I need to obtain some certified copy of document, maybe, well, some direction may be given to the registry to, my lord.
What?
My lord, I need some certified copies of some document, my lord. So as to assist the court, my lord. Also, well, some direction may be given so that in the meantime, my lord, they provide, my lord.
No. You get the copies from the registry.
My lord,
You apply for
my lord,
copies.
my lord, I'll apply today.
In the manner how you apply for copies, registry will provide. Why should I give a direction here?
I'll apply.
May it please, lordship. I'm back to mention it is an MSA appeal, my lord, for a listing under orders column on next Wednesday, my lord. The matter was last listed in 2021, my lord. Thereafter, the matter has not come up. On
You'll have to, you hurry, you go to court number 14.
May I please the lordship? With the consent of the other side, I beg to mention item number 22 and 23, lordship. Lordship, my senior Mr. S. John has some personal difficulty, lordship. Kindly adjourn for that.
Learned Counsel Miss
R. Dev.
on behalf of Learned Counsel Mr. A.R. So representing the appellant
After
has
3 weeks, please.
with the consent of the other side
Yes,
has
lordship.
paid for adjournment, list the matter on
After 3 weeks, lordship.
after 3 weeks.
Oblige, lordship.
May it please your lordship, I beg to mention item number 9. We have taken consent from the other side, lordship. Lordship, the matter may be fixed on 27th. And
Learned Counsel Mr.
lordship, the interim may be continued.
For the appellant,
Yes,
what is your name?
M. Ahmed.
Your name is not,
On behalf of MSR Chaudhary.
Learned Counsel Mr. M. Ahmed,
Yes,
on behalf of,
MSR Chaudhary.
her name is also, oh, on behalf of Learned Counsel Ms. R. Chaudhary, with the consent of the other side, has paid for adjournment, list the matter on 29 June, colonic 27 May.
Yes. Lordship, an interim may be continued.
Interim order shall remain in force till then.
Published.
May it please your lordship, with the due consent from the other side, I beg to mention item number 27. Your lordship, in this case, there is already a talk of compromise going on between the parties. Kindly list the matter in the upcoming Lok Adalat.
Lok Adalat আছে নাকি? Any date has been fixed
14
for Lok
June.
Adalat?
14 June. In 14 June.
Any date fixed for Lok Adalat?
14 June.
Are you aware?
As
I am
per-
not aware.
As per Google. Google.
You want it on the Lok Adalat or anywhere in the court or in the Lok Adalat?
Upcoming Lok Adalat. She was telling it was 14 June.
We'll wait for some time. One,
Any talk of compromise?
we'll wait for,
Lordship, this may be adjourned after 2 weeks. This may come up after 3 weeks. A talk of compromise is going on, Lordship.
okay, okay. Learned Counsel Miss
Du Roy, appearing on behalf of Mrs. S. Roy.
Yu Roy, appearing on behalf of Miss S. Roy, Learned Counsel representing the insurer.
Appellant.
You,
Insurance. company.
appellant insurer, with the consent of the other side, has prayed for adjournment as the matter is, as both the parties are willing to settle the matter amicably. List the matter after 2 weeks.
Much of that.
Please, your lordship, I beg to mention item number 4 in the daily list today with the consent of the other side.
Lordship, a date may kindly be fixed. 5th of June.
Learned Counsel Mr. R. Sensor, with the consent of the other side, has prayed for adjournment, list the R. Sensor for the appellant, लिख दीजिएगा, हाँ? For the petition.
5th June.
List the matter on 5th June.
Object.
May I please your lordship? I beg to mention item number 9. Kindly adjourn of the day. Next.
Yes,
next.
adjourn, next day.
Thank you.
Item 1.
My lord, item 1 may be taken up along with item number 5 because their trial court records are there and it is arising out of the same case records. My learned friend is here, he can start, my lord. You are arguing in this matter earlier.
You'll get double promotion to item number 5 now, or I'll take up when the item reaches.
Yes,
My lord, as per convenience of this court.
Let it be, Lord.
Okay, we'll take up item number 5, Lulu. Item number 1.
My lord is taking up now.
Because item number 1 has been called, so we'll
Ye-
take it up.
Yes, Lord.
You have for item number 1,
Item number 5, lordship.
item number 5. Why item number 5 before before item number 1?
My lord, item number 1 is motion matter and item number 5 is hearing matter, lordship.
Okay,
Since trial court records are there, that's why I
okay,
take my.
it's okay.
My lord, may I kindly take up item number 5.
Hmm.
Dear lordship, the petitioner was arrested on 31st of March 2023.
Okay,
Charge sheet was submitted on 20th of July 2023.
27, 23.
23.
Okay.
In this case, lordship, charges are yet to be framed. Cognizance was taken on 19/9/2023. Lordship, I am seeking bail, lordship, in this case primarily on 2 grounds. Number 1, lordship,
Cognizance was taken on 19.
19/9/2023.
Yes.
My lord, I am seeking bail in this present case primarily on two grounds. Number one, long incarceration, undue delay in trial. And number two, lordship, ground of arrest.
That is
Ground of
number
arrest.
one, I know.
Yes.
That is number one, not number two.
In this
Grounds
case,
of
lordship,
arrest.
total witness lordship cited is, I think, 9. And lordship, as of now, lordship, the stage of the case is supply of copy. Why? One person, Atikur Rahman, he was absconding. Now, lordship, he is not absconding anymore. My lord was on the last occasion, lordship, I have placed 2-3 judgments. I will start from there.
No. Only 2 judgments, not 2-3 judgments.
2 judgments. I'm sorry, lordship. I will place,
No, we have 2-3 judgments, but you'll place only 2 judgments.
I will place another judgment today, lordship. On the last occasion, lordship, lordship may kindly take up bail application number 3015 of 2024. Order dated 8/4/2025.
My order?
Yes, lordship. Lordship's order.
Yes.
My lord may kindly come to page number 5. Paragraph number 10. In that case, lordship, may I read the paragraph number 10?
Yes, yes.
I have considered the length of detention. The petitioner has been behind the bars for more than 1 year and 10 months. Here, lordship, the petitioners are behind the bar for more than, lordship, 2 years and, lordship, 2 months almost. Not a single witness has been examined so far. It is true that the petitioner was intercepted while he was carrying 300 grams of suspected heroin. And this is also a case of heroin, lordship. And he is booked in a serious offense. But at the same time, it is apparent that trial has been procrastinated by the state as well as by the court. 8 witnesses are enlisted in the charge sheet as cited witness, and not a single witness has been examined. Now, lordship may kindly come to the next paragraph, paragraph number 11. I have relied on the decision of the Honorable Supreme Court in the case of so-and-so, 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 wherein right order dated so-and-so, the appellant so-and-so was granted bail for incarceration of 17 months. In the light of the above decision of so-and-so case, the present petition is allowed. Now, lordship may kindly take up the next case, lordship. That is Criminal Appeal 3379 of 2024. Dhirendra Kumar Chaudhary versus State of Assam.
This has been cited.
Yes, lordship. This has been cited, lordship. Now, lordship, the another judgment, lordship judgment I am placing. This is, lordship, order dated 25/4/2025. Lordship may kindly come to page number 4. Paragraph number 11. I have relied on the decision of Honorable Supreme Court in so-and-so and so-and-so. The petitioner has been behind the bars for 2 years, 1 month, and charges have not yet been framed. So, considering these 2 decisions on the ground of non-furnishing of the ground of arrest, the bail petition of the petitioner therein was arrested, as well as length of detention, lordship. Now, lordship may kindly take up the additional affidavit, lordship, which I have filed in my case. Page number 146. Running page 146. Name of the petitioner is there, Abdul Qadir, 40 years. Then, lordship, no ground of arrest is there in the inspection memo. Then, lordship may kindly come to page number 147, notice issued under section 50 CRPC. You are hereby informed that you have been put under arrest in connection with so-and-so, so-and-so, and you will be prosecuted so-and-so today on so-and-so in connection with the same, since you are not enlarged on bail from the PS, as the sections are non-bailable. So, no grounds of arrest are there, lordship. So, lordship, primarily on these 2 grounds, lordship. First, undue delay in the trial, prolonged incarceration, and second, lordship, ground of arrest were not furnished to the petitioner. Lordship may kindly allow me to go on bail. And lordship, apart from that, lordship, the judgment, lordship, the other judgment which lordship has already relied on, Vihan Kumar and Probir Prakashta, Lordship. I am not going to read those judgments, Lordship. And Lordship, if need be, Lordship, I will furnish the copy, Lordship. And so far as the notice issued under section 50, those are there in the record, Lordship. I have flag marked it, Lordship. So first ground is, Lordship, prolonged incarceration, and second is, Lordship, Vihan Kumar.
Lordship, here my learned friend has taken two grounds, my lord. Basically, prolonged incarceration and grounds of arrest, my lord. Here, admittedly, there is delay, but that delay has been caused because one of the accused person, he was absconding. And my lord, PNA was issued ultimately on 5/2/2025. The case was split up, my lord. Case was split up, and there is a report from the court below, my lord. I have flag marked it in a blue flag, my lord, the record. So, my lord, on 5/2/25, the case is split up. So the delay was due to the fact that the accused was absconding, my lord. And my lord, in this respect, my lord, right now I don't have, but I would like to point out, my lord, the NCB versus Mohit Agrawal case. The lordship is aware about that case, my lord. In para 18, I will place the judgment, my lord. So, my lord, here the delay, because delay is subjective, my lord, case to case. It will, because Supreme Court has not fixed any particular period that this is the period you have to consider. Because it will depend upon the cases to cases, my lord. Although here no witnesses has been examined, but the circumstances such that, my lord, it cannot be proceed at that time because the person was absconding, my lord. Right now,
Grounds of arrest.
then grounds of arrest, my lord. Here the person was arrested, my lord, on perhaps, my lord, 2023. 2023. Here, my lord, what has happened, the your lordship pointed right down the point, my lord, because these points, the grounds of arrest, non-furnishing of grounds of arrest in written form, was first discussed in Pankaj Bansal case. My lord. That Pankaj Bansal case was passed in 3/10/2023. And Pankaj Bansal case, it was specifically mentioned that it will be henceforth, you will have to provide the
Written grounds.
written grounds of arrest. And that proposition has been confirmed by the case, not Probir Prakashta. That proposition has been confirmed by the Ramkishore Arora case, my lord. Ramkishore Arora.
Ramkishore.
Ramkishore Arora, my lord. That I will place, my lord. In Ramkishore Arora, Supreme Court has specifically stated that the writing grounds of arrest has to be provided. The meaning of the Pankaj Bansal will be prospective per se from the date of 3/10/2023. And here this person was arrested prior to 3/10/2023. So here, because your lordship see here in Article 22(1), there is nothing that you have to give him in writing. The words are, you have to inform him.
Discuss in Vihan Kumar's case.
In Vihan Kumar's case, my lord. But
in
Vihan Kumar,
additional
thing, my lord.
support from
Yes, my lord. But because the thing,
other judge also.
my lord, in Pankaj Bansal, then Probir Prakashta, then Vihan Kumar. So Vihan Kumar is nothing but a culmination of Pankaj Bansal and Probir Prakashta, my lord.
There is nothing to.
Yes, my lord. Because in fact, in Vihan Kumar, your lordship, if your lordship go to the Vihan Kumar, that those conclusions, there is nothing that you have to give in writing. In Vihan Kumar, it was written as the mode and manner the person understands. The mode and manner. In Probir
conclusive part, there you have to give the grounds of writing.
Yes, my lord.
Yes.
In
Which came up afterwards.
afterwards,
It's not annexed with the
In-
earlier judgment.
but in my
Now,
lord,
Lordship, it is an-
Came up afterwards. Earlier judgment, I got the earlier judgment.
no, my lord, it was
Downloaded from the website.
no, my lord. It was view of the Honorable Justice Koteshwar Singh in the later part, my lord. But my point is that, my lord, this all writing thing has come from Pankaj Bansal, because Vihan Kumar also relied on Pankaj Bansal and Probir Prakashta. And Pankaj Bansal case, the Supreme Court has said then in Ramkishore Arora that you have to give it in writing. That proposition will affect from the date of judgment of Pankaj Bansal, that is 3/10/2023. In fact, in a lot of cases, my learned friends knows, my lord, I have argued in different courts that there are different views. And my lord, recently in of our High Court, my lord,
I think I have also discussed that point.
yes, my lord, actually
But later on, that part came up, no? It
Yes.
was not earlier circulated, so then, when that
No,
part
no,
has been
that is
added. then
concurrent
I
view, Lordship.
stopped.
Concurrent view of Honorable
Yes,
Justice
my lord,
Varseshwar.
I am not disputing here Bihan Kumar or Prabhu Kaishla, my lord. Bihan Kumar, yes, it has to be given in writing, but these things has come from the Pankaj Bansal judgment started, and Pankaj Bansal judgment is prospective in effect. Supreme Court has said in Ramkishore Arora, my lord. And my lord, I have recently, my lord, in our High Court, bail application number 1100/2025.
Let me see again, if there's a
My lord.
different view.
My lord, I have only one copy.
Let me read it then. এইটো ডাউনলোড কৰি লওকচোন এটা।
আছে।
extra copy আছে। Double one, double zero, two.
Double one,
Oh, GJ, first one, yeah.
And then this matter is sub judice also.
And sub judice also,
Mm.
my lord, because here what has happened in different in the Honorable Justice Mitali Thakuria's court, my lord, I have argued in a bunch of cases that initially I have taken 2 points, my lord, that if a person is caught red-handed, then this proposition will not come, and second, this whole proposition is prospective in nature. So although my argument was, my lord, bail was granted, my lord. But subsequently, in this court also, Honorable Justice K. Goswami's court also, I have argued in a case, my lord. Their bail was considered, but subsequently in this judgment, the Honorable Justice has said, this Pankaj Bansal judgment, this whole thing, my lord, the grounds of arrest to be given in writing has to be considered prospectively. From the date of judgment of Pankaj Bansal 10.
This is a matter to be pondered about now.
Yes, my lord.
We'll have to ponder over the matter now.
My lord, in para 25, your lordship may kindly go through para 25.
Para 25, yes.
Yes. I'm sorry, my lord, I don't have those cases today because I could not go through the scan copy. Today morning, I have gone through the scan copy. I can place all those judgments. And different high court judgments are also there, where it has been said that, my lord, it has to be prospective in nature. Because why? Because, my lord, in Article 22(1), there is nothing in writing that you have to give in writing. That things initially discussed in 1962 in a constitutional bench judgment, where it was discussed in respect of preventive detention. And that judgment was taken in Prabhu Purkaisto, and based on that judgment, my lord, Prabhu Purkaisto judgment was passed. That, yes, we can take this proposition in Article 22(1) also, so you have to give in writing.
UAPA Act, no? UAPA Act.
Prabhu Purkaisto UAPA Act, my lord. But there is one line in Prabhu Purkaisto, in perhaps one paragraph, my lord, where it says that it is under Article 141, so it will be law.
Yes, yes.
Yes, in Prabhu Purkaisto that has been written, but
Yes.
Prabhu Purkaisto also.
That is the sole reason why everybody is
Yes,
following.
but the thing is that is prospective, because prospective in the sense from the date of judgment of Pankaj Bansal, because in Prabhu Purkaisto also, this Pankaj Bansal judgment was discussed. Before, in fact, before that paragraph, prior to that paragraph, my lord, this Pankaj Bansal judgment and the judgment which I have relied, the Ramkishore Arora was discussed, but the situation in Prabhu Purkaisto was different because the person was
different.
yes, well, because in Pankaj Bansal, what happened in Prabhu Purkaisto, the person was arrested on the day this Pankaj Bansal judgment was passed. But there is a delay in uploading the judgment. That aspect has been discussed in Prabhu Purkaisto. So they didn't deny Ramkishore Arora judgment, my lord. That is in fact intact, my lord. That has been passed by the Supreme Court, my lord. So in my view, my lord, this person has been arrested prior to judgment of Pankaj Bansal. So this proposition will not come because why? Earlier it was not mandated that you have to give in writing. So the law enforcing agency, in fact, the courts are not at fault. So your lordship knows when a person is arrested, the law enforcing agency, in fact, the court below, relied on my lord D.K. Bosu's judgment because that was the law. This proposition came after Pankaj Bansal, my lord. So Pankaj Bansal, Supreme Court says it will be prospective. Pankaj Bansal, it was in PMLA case, then Prabhu Purkaisto UAP added. Then Vihan Kumar, it was generalized.
PMLA only.
In fact, my lord, Vihan Kumar is,
Vihan Kumar
in
is
my view,
PMLA.
Vihan Kumar is nothing but culmination of Pankaj Bansal and Prabhu Pugashna. So this person was arrested prior to the judgment of Pankaj Bansal. So, my lord, that view, that whether he has to be given in detail in writing, that will not.
And moreover, I would like to see this, everything is given in writing. Everything is given in writing. And he is accepted in English. He has
Yes.
given his signature in English. So how much
Yes.
communication he requires?
And my lord,
But
it-
yesterday, unfortunately, your case, I think,
Yes.
98 days, only 2 cases, I think.
2 cases.
98 days, granted bail.
my lord, in fact, if I am not wrong, my lord, in Vihan Kumar,
And the cases are also very heinous cases.
yes,
One is 4,000 kgs of Yaba tablets.
No, my lord. Mine is only 225 grams, my lord.
No, one I have granted bail is
Is it,
4,000.
I guess, my lord, is item
And one is
51.
1,000 kgs of ganja in a truck.
yes. And in fact, in Vihan Kumar, in para 24, if I am not wrong, my lord, not only in Form 50, my lord, in Section 50 notice or 50A notice, my lord, to my understanding, my lord, you have to give in a separately.
Relatives also.
Then that's relative also, but in separately the grounds of arrest, because
Separate
the
grounds of
word
arrest,
is
yes.
in addition to the grounds of
addition,
arrest
yes.
mentioned in Section 50.
In addition.
Yes, my lord, in addition, the word is particular addition, but these things will come after Pankaj Bansal judgment, because prior to that, there is nothing that you have to give in writing. The information is sufficient, my lord. And so here he was arrested, my lord, prior to judgment of Pankaj Bansal.
So this judgment, paragraph 25
25.
is discussed.
Yes, Ramkishore Arora discussed. my lord.
Okay, then I'll go through it and then I'll pass
Yes,
the
ma'am.
order. I'll go through it.
Lordship, may I reply, Lordship?
Of course.
2 grounds, Lordship,
Hmm.
on which, Lordship, I would like to reply. Number 1.
See, you were arrested on 5 to, so the co-accused was, no. This case was split up very recently by the court.
On
So
5-2.
I understand it was the procrastination of the court also.
Yes, yes.
So that part you don't have to reply. That much I understand. When the
I'm
case
relying
was
on
split up-
judgment of our High Court, Lordship, that to division bench. That to in the year 1976, it was passed, Lordship.
I know.
Ajit Sharma.
Yes.
Ajit Sharma.
Ajit Sharma's case.
Yes, Lordship. Paragraph number 6, 7, 8, very clear and
Division
very
bench, so
specific.
this will not lie. Then
My lord.
when the division bench judgment comes, this will not lie.
Very specific,
Madam.
Lordship. And Lordship,
Then,
in this
madam,
case-
I will rely on Ramkishore Arora judgment.
Ram Kishore.
Yes, madam, Supreme Court judgment.
Okay. Then you give me the judgment.
Yes, I will give.
First, Lordship, the delay.
I know that case.
No, Lordship. First,
Everybody has been arguing that case, Ajit Sharma's case.
Lordship.
You
In
give
the,
me the copy of the
in
judgment
the base of
That will suffice.
petition, Lordship, where my
That
learned
will
friend has
suffice.
argued, Lordship. On
And
the
the
other side, I
paragraph
was
also.
there. Yes.
and a paragraph
In-
also.
Yes, Lordship. One thing, Lordship, the first ground, Lordship, that delay was due to the absence of co-accused.
Hmm.
The same argument was advanced in a case, bail application number 3720 of 2024, order dated
Yes.
20/12/2024.
Yes, I have it.
Only one paragraph, Lordship, I am reading.
Which one?
Paragraph number 9. I have not furnished the copy, Lordship. I'm
No,
having-
you have given me the copy. Bail application, Zubair Ahmed.
Zubair Ahmed, yes.
You have given me.
Yes, sir.
I'm sorry, Lordship. Paragraph number 9. Learned additional public prosecutor also submits that as the quantity of contraband seized in this case is of commercial quantity, the embargo of Section 37 of NDPS Act 1985 is applicable to this case. He also submits that the benefit of bail on the ground of prolonged incarceration may not be granted to the petitioner, as the charges were framed in this case only on 37/2024, and there are 8 witnesses who can be examined immediately. He also submits that delay in proceeding with the trial occurred not due to any fault on the side of the prosecution, but because of one of the co-accused was absconding, and the case of the present
you
petition.
see, when the court takes time to split up the case, then the delay is on the side of the court also.
Yes, Lordship. Even
So you don't have to worry about that.
yes, Lord. Even Lordship, when Lordship first rejected my bail 1.5 years back, then Lordship's observation is there. Lordship asked them to split up the case. I have annexed that order, Lordship. my reject order. Even,
No, I'll seriously consider the delay part.
yes, Lord.
Maybe grounds of arrest, he has a point maybe. Let's see what point he has. Let's see. Let him furnish that Ram Kishore's judgment. Because nobody has given me that judgment. They have, they all have given me public requesters, Bihan Kumar.
In fact, my lord, I didn't got a chance to argue here because a lot of courts I have done this, my lord, because your lordship was not taking this special bench. So,
1 minute, huh?
Yes.
How many witnesses are there in this case?
my lord,
15 witnesses are there.
15 cited
15.
witnesses there.
15 witnesses.
my lord, delay is there.
What
Delay
is the
there.
contraband?
My lord,
Contraband not recovered from-
Contraband was not recovered from the possession of the.
No, it's
petitioner.
okay, but the.
1.5 kilo of heroin, lordship.
Yes, 1
But lordship, if we,
One
go-
half kilo of heroin.
Yes,
my lord, if lordship allow me to make one submission.
Okay,
If lordship peruses the entire record, there is nothing against the petitioner. No co-accused has stated anything
that is
against the
not required
petitioner.
now.
And
That is
lordship, the
not
petitioner
required.
in the FIR, in the forwarding
Your
report, it is,
best ground is delay. That is not
yes,
required.
yes,
now.
lordship. Moreover, lordship, the petitioner was arrested only because he was the owner of the vehicle. And the vehicle was arrested by, used by his brother.
This, what is his name?
I think
I-
first is
Abdul Qadir.
Abdul Qadir.
Abdul Qadir.
and item 1 is Abdul Hasim Khan.
Okay.
It was judgment to be.
Owner of the vehicle.
My lord,
He is the owner of the vehicle, my lord.
Abdul Qadir, owner of the vehicle.
Both the petitioners are forwarded on the same date, my lord.
Same
Arrest-
date.
Yes, my lord, yes.
Only what is the difference? He is not the owner.
No, my lord, he is not the owner.
He is a driver or
No,
anything.
no, my lord, only a confessional statement was made against the,
What is his name?
Abdul Hasim Khan, my lord.
Based on confession statement
Yes,
of
yes,
co-accused.
yes, my lord, yes.
my lord, it was supposed to be delivered to Abdul Hasib Khan.
Yes.
And this Abdul Qadir was, my lord, the owner of the vehicle. And my lord, they are in constant touch. There are CDR analysis, my lord. Not only co-accused statement. My lord, in delay part, I will rely on 2-3 judgment. I will give a copy to my learned friend also, my lord.
And that other judge,
Yes,
Ram
yes, yes.
Kishore judge.
And this judgment, lordship, I am placing lordship.
Yes, yes.
Ajit Kumar
Ajit
Sharma.
Kumar, okay.
What is my exact statement?
লিখা আছে? এইটো এটা item number 1 লিখা heard learned counsel Mr. M. H. Chaudhary for the petitioner and learned additional PP Mr. R. R. Kaushik for the respondent state. Fix for delivery of order. Heard learned counsel Mr. I. Hussain
M. Ahmed.
M. Ahmed for the petitioner A2 number 5. And learned additional PP Mr. R. R. Kaushik fix for delivery of order. All right. I'll need at least 4-5 days.
Yes. My lord, only one aspect, if lordship permits me to make a submission, my lord, that my learned additional PP has stated that it was the Pankaj Bansal judgment from which the written grounds of arrest has to be communicated. But my lord, in that regard, if lordship peruses the Prabir Purkashta judgment, that judgment, my lord, discussed the constitution bench judgment which was rendered in 1962. And Prabir Purkashta judgment, my lord, considered the same aspect, considering the, my lord, constitutional bench judgment. That proposition has been laid down by applying Article 141.
Nobody has given me Prabir Purkashta judgment today.
Yes, my lord, yes.
Nobody has given me.
And
Give
my
me
lord-
a copy there.
Yes, yes,
Yes,
lordship,
yes,
I'm having.
I'll mark the paragraph, my lord, and very elaborate, only reliance was
You
made,
mark the paragraph
Yes,
and give
ma'am.
it to me.
only reliance was made on the constitutional bench judgment, thereby held that written grounds has to be communicated, my lord, in writing in paragraph
That
number
is
9.
there in Prabir
Yes, ma'am.
Purkashta. I have read
My lord,
them
that
many times.
aspect I have already spoken because that aspect in the judgment which my learned friend is referring to
Yes.
in Prabir Purkashta, whose judgment was referred, that 1962 judgment, that is in respect of 22(5. That is preventive detention.
Yes.
The procedure in preventive detention is something different, arrest is something different, your lordship knows. Relying on that judgment, Prabir Purkashta said that, my lord, yes, this can be applied in 22
Yes.
1 also in arrest also. So in 1962 judgment, they didn't say that while arresting you have to give in writing, but for preventive detention you have to give in.
That I have read, that
Yes,
part I
ma'am.
have read,
So there is a difference between preventive detention and arrest, my lord.
that part I have read.
And my lord, that is why Honorable Apex Court said that the
Have you marked the paragraph?
in Province Purkayastha, I'll give a short note, my lord, writing the paragraph, my lord, indicating the paragraphs. In paragraph 18, Lordship will find that since the language of 22.1 and 22.5 are same, Apex Court said that it will ipso facto apply to the both the
Yes,
provisions,
yes,
my lord.
yes.
And thereafter it was held that, my lord, that writing
You have marked the paragraph, no?
definitely
What is the para number?
paragraph number, my lord, it starts from paragraph number 24.
Onwards.
Yes, my lord, 24 onwards, and then my lord will Lordship will find up till 29. They have discussed the judgments, how it has to be, how it has interpreted, and how it has been applied, my lord. And thereafter, my lord, it was held that written grounds of arrest has to be communicated. And my lord, moreover, my lord, paragraph 45, Lordship has said that they have applied the power under Article 141. So until there is a specific line that
Paragraph 40?
45, my lord, where Honorable Apex Court said that
Yes, yes.
yes. So my lord, until the
45, no?
45, that we are it has to be applied prospectively. It since it is not there, my lord, so we know the law will be applied retrospectively, my lord. And another aspect that section 50, that grounds of arrest is not required to be communicated, my lord, that argument was made in Vihan Kumar's judgment. And my lord, Vihan Kumar judgment, I'll also give, my lord, in paragraph 19, Supreme Court said that if you are arguing that written communication of grounds is not necessary, then section 50 will be void. So my lord, I read the article 13. Article 13 says that, my lord, any law made inconsistent or in derogation of fundamental rights is void. So if the argument is that 50 is not required, 50 written communication of grounds is not required, then it will be void, my lord, as has already been held in Vihan Kumar.
My lord,
Because that is going to directly affect my fundamental rights, my lord. We are going to abridge the fundamental right by applying section 50.
my lord. Hold on.
Constitutional provision
Yes.
from the date
Yes,
of the
yes.
Constitution.
My lord, we adopted the constitution in January 1950. 26, so it is
Extended
there, my lord.
provisions
The
are there.
protection has been given. Fundamental rights in part C has been enacted, my lord, effect from 1950, my lord. So how can it be, my lord? And Constitution bench also held that written grounds of communication has to be given, my lord.
My lord, here my point is my friend is right. But the thing is that Constitution is from the date of 1950, 26 January 1950. But nowhere in Constitution, Article 22.1 or 22.5, it is written that you have to give in writing. The only word is that you have to inform. So that is the law that has been going on. That's 1962 judgment, as I have already said, my lord. That is regarding preventive detention. Then in Vihan Kumar, I am not saying that section 50, because why section 50 came? Section 50 came in compliance of Article 22. That is the reason, my lord.
What is
And
the
1650A
Yes.
come after Hussain Ara Khatun judgment, ma'am. But the thing is that, my lord, in writing, that proposition initially came in respect of Article 22.1, because there is a difference between Article 22.1 and 22.5. In 22.1, that came in Pankaj Bansal case. Then, my lord, in Vihan Kumar specifically said that I am not saying that you don't have to give your section 50. I am saying you have to give section 50 along with grounds of harassment. That is the law in Vihan Kumar, my lord.
Yes.
You have to give
Yes,
section
yes.
50. But to my understanding, in para 24, it has said that grounds of arrest in addition to
In
section
addition,
50.
yes, in
So
addition,
meaning
yes.
thereby you have to give grounds of
I
arrest
think
separately, my lord.
vividly,
You have to
in
give.
addition, yes.
This is the law. I am not denying that. But the only thing is that my point is that before Pankaj Bansal, if you giving him section 50 notice or you are informing him there is a note in CD or in remand order, in remand, my lord, forwarding, sufficient, because there it was prior to that it was not mentioned anywhere that you have to give him separately grounds of arrest in writing, my lord.
That remand argument they had made, and then the one case I have rejected bail, I think their case
Remand
only.
order, that also, my
That
lord, specific.
forwarding order.
Yes, forwarding, my lord.
Rejected your
Yes,
bail.
yes,
I
my lord,
think
include the
somebody's
judgments
bail,
in
that is
Province
why
Purkayastha as well as Vihan Kumar.
I
They
have
said no,
rejected on that
Yes, yes.
ground.
it will not
Forwarding is
suffice.
mentioned in the
And
forwarding.
Pravi Purkayastha, my lord, also discussed the Ramkishore Arora. Your lordship, if your lordship goes through the Pravi Purkayastha judgment, your lordship will see.
Okay. And Pankaj Bansal, which paragraph?
Pankaj Bansal, I'm not relying, my lord, see.
If Pankaj Bansal-
We can, my lord.
I don't want that.
Yes.
You are not relying, then I don't want, do not.
We will definitely provide, my lord, the copy.
No, you are not relying, no?
No,
Pankaj Bansal?
my lord, I have only argued on the best, on the Pankaj, Prabir Mukesh's judgment.
And,
So you can take it back.
and Lordship, one last part, Lordship. Lordship, in Abdul Qadir's case, Lordship,
No, not anymore.
last one line.
No,
Lordship.
no.
Lordship's order, just one line.
I know. that,
Ground of
uh,
arrest, Lordship, I'm not, that is my second ground,
I
Lordship.
know. I have directed to expedite it.
Yes, Lordship, and that was, Lordship, on 1/5/2024.
I know 1.5 years back.
Yes, Lordship, yes.
That's why I'm saying no.
Lordship, I'll hand over the Prabir Mukesh and Bihan to, put Master Sermon. Bihan and.
You have given Prabhu Prakash.
Okay.
But Vihan Kumar, I don't think you have given.
Bihan, I have my lord with me.
Let me check.
And not the specific paragraph, my lord, which line on.
No,
I-
Vihan Kumar, you haven't given.
I have my lord, I have the copy.
Adi ki tarik hai? 15 का argument of the day. 15 5 3 का argument से. itu ya ऊपर रखे दिया है ना modification bill khatam pasal buhay din dito na may pasal pahui siya no
Paragraph 19. Item 2.
Highly applies.
Beg your lordship. First of all, my lord, on behalf of my client, on behalf of myself, I borrow my head out of oblivion, my lord. There is an application under 483 of BNSS, my lord. In connection with Dolgaon Police Station, Journal Diary entry number
we need your
011.
CD
Scan code.
can copy submit also record
It is a statutory matter fixed for evidence, my lord, but
so
I
we
just.
need the scan
Yes,
copy submit
my lord, why I'm telling you, my point of argument is that the delay. My point of argument is, my lord, I just
Yes,
want to
but,
remind your lordship, my lord.
argument after we get the scan copies of the child court record
No, my lord, because my lord, I just want to bring to your lordship's kind attention to
no
Annexus 6, my lord.
no we will call for the scan copies of the child court record we'll call then we will consider your
And we have
submission.
given it, my lord.
Huh?
We have given it, my lord.
No.
Annexus 6, my lord.
We'll call for the scan copies of the child court record from the child court.
Because, my lord, my bail petition was not heard for 2 months.
I'll hear you.
I filed a bail
I'll fix
petition.
it on the next week. We are calling for the scan copies of the all
My
the
lord,
scan copies.
my
We'll
lord,
get
my
it.
Next week, my lord. My lord,
It's through email, we will get it.
yeah, can I get a, my lord, fixed date, my lord?
Yes, sure. Hard learned counsel, Mr. S.A. Rahman for the petitioner and learned additional PP, Mr. R. Kaushik for the respondent's date. Call for the scan copies of the child court record along with the scan copies of the CD. Please done better on of the date of the date. 21st May, okay?
My lord, obliged, my lord, highly obliged.
Item number 6 for orders.
May it please your lordship. My lord, my lord, in this case, actually, in IA number 469 of 2025. Oh, I am for the respondent.
Okay.
In 469 of 2025, kindly see IA. There was an order that today the case will be heard in finally, my lord. Expeditious hearing petition was allowed. 469 of 2025.
Yes.
My lord, I have been newly engaged in this case, my lord. Today it has been listed for orders. My lord, there are 3 IA. One is for substitution and one is for condonation and one is for abatement. On condemnation, today on condemnation petition, notice will go.
No, my lord, I have objection, my lord.
How?
Because
A
why I have
substitution,
objection?
How?
No, no, why
objection?
I have objection, my lord? For delaying the case, this petition has been filed. Why? In the original plaint, they are the defendant number 14. 14 in the original plaint, never contested. It was ex parte against 14. In an appeal also, not contested. Now in the second appeal, after service of notice, I am appearing the main respondents. They are the pro forma defendant in the original case also, in the appellate case also. Now also they are the pro forma defendant. Now they want to substitute the person who was against whom the ex parte order was passed in the plaint, in the trial court.
They have not contested it.
Not contested.
In the title suit, in the appeal.
Appeal, no,
never.
nowhere. I will show, my lord. Kindly see the appeal memo, my lord. Page.
But just a moment.
That is why on last
condemnation of
occasion.
delay is not required from them, I think. Their view on condemnation of delay is not required.
In case they are
They have not
substituted,
considered, they have not been made parties.
Kindly see,
They
kindly
are
see.
pro forma defendant.
Pro forma defendant and not
in case your
contested.
lordship observed that their appearance is not necessary, I am not.
Yes.
In case your
That-
lordship
that I don't
observed that.
consider.
No, no, that,
Now,
that,
otherwise my notice has to go, this petition has to
that
be disposed
observation
of.
can be made, my lord.
This application has
Since
to be.
they have
disposed
not
decided
contested.
first, my lord. Other, how could it be? And how my learned friend could give objection to for substitution?
Kindly see, my lord, page, memo of appeal, page 28, my lord. Why I am
What is the
objecting?
hurry? They are in possession.
No,
What is
no.
the hurry?
Hari is, my lord. Why Hari? Kindly see the IA. IA copy. Why I am
You
Hari,
have
my
to
lord?
follow the procedure. No? One of the respondents
Kindly
has
see
right,
the
have a
IMI.
right to substitute them. If your lordship reject that, then
Why
is
I
a-
am Hari,
have
my
no
lord?
objection.
I am shown in the IA, my lord. Kindly see the IA, my lord. Dispose of IA. 469. One page I will show, my lord.
How it could be denied?
Why I am Hari, my lord.
How it could be denied?
Kindly see the IA, my lord.
Substitution matter.
No, substitution, what? They have not contested. Pro forma defendant.
The
Then
application
in
has to be
appeal.
decided. Application has to
Then
be decided
appeal.
first.
And apart from that, in the condonation petition and as well as in this present case, the address is also given wrong address. Today, if it is allowed, then notice will go to the wrong places. That is why they are, in spite of the order passed by this honorable court on last occasion, kindly see, that is why I am showing
If
the
your lordship direct
order of
my lord, I
IA.
shall serve doctrine notice on them within a short period of time.
Kindly see IA, my lord, 469. Kindly one order I will show, one page I will show, my lord. Page 15, my lord. Page 16 of that IA. Why I am Hari, my lord. Concurrent finding.
Position, no?
No, concurrent finding. Why I am
He is
Hari?
in possession. He is in possession.
I am showing, my lord, page 16. Why I am Hari, my lord.
Okay.
Page 16. In view of the projected made pendency of the second appeal number so and so with regard to the right title interest in respect of 12 kathas of land out of subject plot, it is provided that at interim measure there shall not be any disbursement of compensation amount in favor of the private respondent. We are the private respondent. In the writ petition, when the injunction was not got in this second appeal, they filed a writ petition, and our through our land, the Assam Mala.
Why are you afraid of contesting writ petition? Why are you afraid?
Assam Mala road has been
Why you
passed
afraid
away,
of
so
contesting writ
compensation
petition?
is to be allowed to us. By this writ petition, by filing this writ petition, they have obtained the injunction order. I have filed contested in the writ
Appellant, my lord.
Appellant
and concurrent finding, my lord. It is not that it is a reversal or anything, my lord. That is why I am Hari, my lord. And this application was after hearing both the parties, it was allowed.
Okay, where is your IA? Where is the other one? Your IA for what matters?
My lord, 10886/2025.
This land has been acquired.
Land has been acquired by the government for construction of road. And now we are not getting the the benefit of that
And why
compensation.
Govinda Chandra Pal is preferring this application?
My lord,
You have Govinda Chandra
Yes.
my Govinda.
Pal. Why are you filing this appeal?
Application, appeal.
Huh?
My suit was, suit and appeal both were dismissed. Against that, I have come before your lordship, my lord. Substantial question of law has been framed.
That land which has been acquired belongs to them or you?
Our.
That
is why injunction order they have obtained.
My claim is that it is our land, my lord. Our land, my lord.
So that compensation has not come to you?
Yes, that is because
How
of the
much-
order.
He is only
Compensation?
possessing.
How much compensation was awarded?
It was not only one respondent,
Or
there are six,
many
many
people
respondents.
in that acquisition
Yes.
case? Okay. Whom do you want to serve notice?
Respondent number 6. I
What
want to
six?
substitute this respondent number 16. He has died.
Okay. This is a condemnation of delay petition.
Condonation of delay petition.
You are?
My lord, kindly see the memo of appeal, page 11. Page 11.
Yes,
This is defendant number 14, kindly see.
yes, yes.
These are, this is, he wants to substitute it. Now kindly see the page number 28. 28 and 30. 28. Only pro forma defendant number 2, 3, 5, 9 and 14 have filed their written statement. Lordship got it? Page
28,
tw-
page number 28, yes.
28. So he has not contested. In the trial court record, I have gone through. It is ex parte against that defendant. Now kindly see the appeal memo, appellate order. Page 49, kindly see.
Hmm.
16. Hirojyoti Chakraborty, 16, page
Yes.
49.
Hmm.
He has not contested, only contested by the, kindly see, who has contested. In the memo of appeal, I have gone through only,
My lord,
we are the contested.
or not contested, CPC
Now-
requires that notice has to be
Now,
served.
since they are not contested in
What
this
is the
case,
provision you?
not contested, they are ex parte.
To show the
Now
provision
question
under
of
the CPC
substitution,
that
how can
if it-
come?
If it is not contested, then notice need not be served. Is what's the provision?
Now how question of substitution come, my lord?
So what's the provision?
That too
it is
after,
it is
after
not,
two,
if it is not contested, then notice need not be served. So
and
what's the provision?
that too after 2 years, he has filed this application, death of 2 years. And in this second appeal also, kindly see, the notice was duly served. Then after hearing, when the case is fixed for hearing, they have filed now this application. So may I pray that since the order has been passed for fixing the case for hearing, let the matter be fixed for hearing on next week, my lord. In the meantime, substitution may be allowed. I will not object on this.
He is different respondent. How he could agree to it? Allow? He has nothing to say. If your lordship pass that order, my lord, I have no objection. But otherwise, you know.
Now
what
he is
locus standi
himself
to-
objecting his petition, my lord.
His locus standi to make submission for a.
Now he is objecting his
What
petition, my
is
lord.
his locus standi? He is not that defendant, respondent.
Now I'm conceding, now he is objecting his petition.
What is your
So-
authority to concede? What is your authority to concede?
See, this land acquisition case. So when the land is, there's a case for acquisition, for the compensation, then there are many respondents. So against the government.
my lord.
So now the government has paid the money. So somebody may prefer to contest and somebody may not prefer to contest. So why you have made so many parties who are not willing to contest?
My lord, these parties were there in the trial court.
They were there in the trial.
They are in the trial court.
No, no, I have shown.
They were the
Trial
parties
court
in the
ex
trial
parte
court.
against this.
I have not
Ex
made
parte.
them new, I have not made.
So I have no
new part.
objection if it is fixed on next week, my lord, because there is an order. Next week, the hearing may be fixed. And in the meantime, the whatever petition they have filed, it may be allowed.
So this matter went ex parte. They are not willing to contest. They are happy with the
If-
compensation, whatever they are
If your
getting.
lordship allows my petition and fix up this case for hearing, my lord, I have no objection. Without notice,
No,
if
no,
your lordship
I-
allow
when-
this petition,
When
but,
you have made them a party, how can I?
but the procedure is that notice has to go.
And so many parties, all the parties' name has been struck off also, my lord. Kindly see the main case in memo of appeal, my lord. So many respondents' name has been struck off due to non-contest. Now, for delaying this matter, this practice has been come. Because
What
in last,
delay? I am the
last
plaintiff,
occasion,
I am the appellant.
last occasion, my learned friend has not appeared in this case, my lord. Last occasion, separate counsel appeared. And this
What is your
point,
problem? What is
this
your
point,
problem?
this
What is
point
your
was
problem?
raised that whether substitution is required or not. Or after hearing both the parties, this court allowed, no, substitution is not required, fix the matter for hearing.
So this is, you are praying for substitution of which respondent? Respondent
That's
number?
for number 16, my lord. 16. Only 1 year, my lord.
Await service report, there is an order on 7/1/2018.
Yes.
Await service report on respondent number 1 to 16. 1, 4, 7, 8, 9, 10 to 16. F. Ahmed Learned Counsel has entered appearance on behalf of respondent number other respondents.
Other
So
respondent.
notice has not been served to respondent number 16. till
No,
now.
then thereafter, kindly see, thereafter it was served. It was served. That is why it case has been fixed. In the office note as well as in the order itself. Name has been struck off also.
Names of some respondents have been struck off,
Oh, yes,
8, 9, and 13.
yes.
To 16 notice has not been served.
Served, my lord. I have gone through this. Notice has been served. All the respondent notice has been served.
No. Not till date. Not served on 16. And then there's an allegation that you are giving a wrong address also, that notice will not go and then.
My
it
lord,
will
I
consist
said,
that-
those notice on them, my lord. No problem.
Correct address I am giving, my lord. What is the correct
That's
address?
Okay, man.
They have given the wrong address.
I am obliged correct address. If he furnish correct address, my lord, I am thankful to him.
So may I pray that this matter may be fixed for hearing, my lord.
So
Because
let's-
already there is an order, my lord. I have no objection if substitution is allowed, all these things.
Let him serve notice to the respondent number 16.
16 is not died, my lord.
I know. Let them serve notice to the
Yeah, legal heirs.
legal heirs.
By way of those things.
Yes. Which one?
My lord,
For continuation of delay.
my lord. 10886.
My lord, may I permitted to go?
Yes,
permit.
yes, should be here.
Mhm.
No, I get up. Who are the legal heirs? You have mentioned their names.
Yeah, I have mentioned, my lord.
To legal heirs of respondent number 16.
Legal heirs of respondent number 16.
Learned Counsel, Mr.
KK Day,
1086.
my lord.
Learned Counsel, Mr. KK Day is present for the applicants, 1086 for Lihiba. Learned Counsel, Mr. SK Ghosh is present for the respondents. He has raised serious objection against the petition and service of notice to the legal heirs of the respondent number 16.
60.
As respondent number 16, what is his name?
Hirok Jyoti, uh,
Hirokjuti
Hirokjyoti Chakraborty.
Sagrapati has passed away. It is submitted that the respondent number 16 never contested the proceeding and he never appealed before the first appellate court against the ex parte order passed against him, despite the fact that he was arraigned as a party to the suit and the title appeal. Number, what is the title suit number? 62 of 2000. 62 of 2000. Full stop. However, for the interest of justice, notice is the respondent number or the applicant is allowed to issue notice to the legal heirs of respondent number 16 through dusty service, routed through dusty service and returnable within 2 weeks.
It will take time in Hailakandi 4 weeks.
No, but he was saying no that.
3 weeks, madam.
3 weeks, no.
And the date may be fixed, Lordship.
Hailakandi, it will not take time so much. 2 weeks. Returnable within data reduction.
27.
আর এসে তো লিখে দেওয়া আছে। Learned counsel. No. Parties are represented, list this matter for hearing on. Okay. Deeply.
Item A for hearing.
The matter may kindly pass over for time being. My senior is in legs.
For time being, okay. 9 to 9 to adjournment.
My lord, I have another matter in code number 14.
Okay.
Hearing matter. So if any other date is convenient, my lord. Next item, item will be
Item number 8.
8.
Next week, Lord.
Yes. As agreed by learned counsel for both the parties, list the matter for hearing on next week at a date video. You want a date?
My lord.
27th of May.
Oh, ঠিক আছে.
Item 8.
I am paying for time being, matter will pass over for the time being, my lord.
Time being?
Time being business
After
is
2
difficult,
maybe.
madam. Let it come after 1 week.
After 1 week.
Date may be.
As agreed by learned counsel for both the parties, list the matter after 1 week. 1 week or should I give a date?
Yes.
Date?
It's up to you, lord. 20. No, after slightly after that. Yes.
Obliged, madam. Obliged.
Item number 11.
May it please your lord. My lord, this is an appeal, your lordship will find, my lord, under section 54 of the Land
Yes, but what
Acquisition
about the
Act, my lord.
government? Against the government,
Appeal, my lord,
land appeal?
under section 54 of the Land Acquisition Act 1894, man. Against the impugned judgment and order, your lordship will find, my lord, dated 7/6/2018, passed by the learned
What
district judge
about
Hailakandi, your lord,
respondent?
in a reference case, your lord.
I understand.
Madam Didi Burman was appearing. She was here in the court actually.
For the
Sometime
government,
back.
no?
Yes.
Court number? She has to be here.
Yes.
When will she be free?
Yes.
Okay, you can start, I think.
Hmm.
Yes, you can start.
No,
Yes.
my lord, there was an estimate. Then there was an award also passed on behalf of the government. For the land, it is 12 lakhs and odd. And for Ziraat, your lord knows, and other things, 7 lakh years. In total, 19 lakhs, my lord, to be awarded by the government as per their declaration and notification. Now, on the land, my lord, there was a fishery, your lord, and lot of fishes were there. That was not calculated by the government land acquisition authority. So an application was made, my lord, for reference to the Rane district judge,
District judge, okay.
and with the hope that it would be enhanced by the Rane district judge after hearing the party dialogue. Now, before the Rane district judge, your lordship, 3 sale deeds of the lands in the locality, my lord, these were exhibited, your lord. Which shows, my lord, that the price of the land.
Check the order. I was in district judge in Karimganj.
My lord, I will be going to all that, my lord.
I'll just check the order.
My lord,
I have passed the order.
I
I'll
am
just
just
check.
placing the, my lord, the summary, my lord.
Hmm.
Now, 3 exhibits were, my lord, 3 sale deeds were exhibited. Now, learned district judge, my lord, did not consider these sale deeds, ignoring sale deeds. My lord, he has come to it fighting, my lord, in the award, and thereby reduced, your lordship, the amount of compensation that were to be awarded by the government, your lordship. Now, with this, my lord, I take your lordship, my lord, to my lord, Annexure 1, page 14, your lordship. Firstly, your lordship. Now, block 3, your lordship, in the middle, your lordship will find, and DAG number 152, 153, go 192, 193. These are the lands, my lord, belonging to the predecessors of the present appellant, your lordship. Now, Annexure 2, page 16, your lordship will find block 3. These are the DAGs 152, 153, 90. These are all these things.
Annexure?
Annexure 2, your lord.
Annexure 2, okay.
2. This is the, my lord, declaration under section 6 of the Land
Yes,
Acquisition
yes.
Act, your lord. And your lordship will find, my lord, description of the land, areas of bigas, rate, this thing, my lord, per biga. So rate, they say it is, my lord, 34,000, your lordship. And in, my lord, amount to be paid for 1 biga, 2 cutters, 15 chotaks, my lord, it is 38,993. That is their calculations, my lord, so far as the land is concerned. Then see, my lord, this is Ziraat, your lordship, regarding houses, trees, and other things. There the, my lord, had calculated, my lord, 7,53,550. Then total compensation, my lord, 11,25,415. And ultimately, my lord, 12,38,054, my lord. That is the estimate, your lord. That is the estimates of probable cost of acquisition of the land under this particular act, your lord. So here, my lord, government has estimated this thing, my lord.
Yes.
So there is no question, my lord, to assess this land again at the rate below what has been, my lord, calculated, your lordship, by the government, your lordship. Now, my lord, turning to, my lord, page 19, your lordship will find, my lord, land acquisition case initiated by the Deputy Commissioner Hailakandi. And your lordship will find page 20, name of the person interested. Firstly, your Abanikanto Sinha, my lord. And my lord, he is the present appellant. And amount allowed for land itself, 38,993, your lordship. Grossly inadequate, your lordship. As per the exhibits, my lord, 1, 2, and 3 exhibited before the learned district judge, my lord. These lands are, my lord, more than 3 lakhs rupees per biga. And here, my lord, from page 19, your lordship will find area of the land acquired, 1 bigha, 2 cutters, 15 chotak, your lordship, more than a bigha.
Yes. Mm.
Now, sale deed says exhibit 1, 2, and 3. Yeah, one sale deed, my lord, exhibit 1 per bigha is 3,30,000. Second exhibit 3,40,000 and then 3,50,000 per bigha. Here only, my lord, 38,993. Be that as it may, your lordships, ultimately your lordship will find, my lord, page 21. And your lordship will find, my lord, after, my lord, adding all this Jirat value and, my lord, value of the crop, hearts, damages, your lordship, ultimately government decided, my lord, that total 11,25,430, that is to be, my lord, to be paid to the present petitioner, your lordship.
Okay.
And your lordship will see page 22, Abanikanto, Sinha, present repellent, 11 lakhs, your lord.
Yes.
And then your lordship may skip, my lord, and come to, my lord, page 31. So 12 lakhs, my lord, for land and Jirat, and there is the fishery.
Yes.
So fishery, my lord, government calculation, your lordship will find 2,27,726.
Yes, yes.
And my lord, on the left hand side, your lordship will find house, trees, and others. So 7,53,550, other than the land acquired, my lord. Land is 12 lakhs or 11 lakhs, whatever it is, and this is 7,50,000. So about 19 lakhs he has to be paid, your lordship, as per their estimation, your lord. And my lord, your lordship will see summarize, better was summarized. My lord, page 34. I am directed to send here is the approved copy of LA estimates amounting to rupees 12,38,335 and award amounting to rupees 11,25,000 so and so for acquisition of land. It is only for, my lord, acquisition of land, nothing more.
Yes, yes. I
Only for
understand.
acquisition of land, no Jirat, no fishery, nothing. Be that as it may, your lordship. Now, accordingly, my lord, when I was not paid, my lord, other than value of the land, that is grossly I need to pay it, and no Jirat, no fishery, no fishes was paid, I made an application under section 18 to refer the matter to the
district
judge. And my lord, your lordship will find, my lord, now the impugned order, your lordship. Impugned order, your lordship will find
I got it.
at
Yes.
page, my lord, 51.
Hmm.
Impugned judgment.
I'll come back after 5 minutes.
Yes.
After 5 minutes?
Yes.
Is there any agreement to pay the amount?
In this case, we have sought some instruction, Lordship, but I think we awaited, Lordship.
Okay, okay. You have sought instructions
Yes, Lordship.
whether to pay the amount.
Yes, Lordship.
We'll wait then. Let them get the instructions. It has been calculated.
I will not be here. I am from Delhi, your lordship now.
Okay.
I stayed in Delhi.
She'll be here, no?
Back, my lord.
Instruction is
By
necessary,
Saturday.
Lordship, in this case, Lordship.
She'll be there.
Now your lordship will read the impugned order and your lordship will find.
Okay, okay. I'll hear
Instead of
you.
increasing, my lord, it has been reduced. That is, my lord.
I'll hear you.
proper
Okay.
year.
I'll come back after 5 minutes. I'll hear you. And then we'll pass an order to obtain the instructions.
Yes, Lord.
And then if not, then we will proceed with the judgment.
Find the impugned judgment, your lord. Now, the instant land acquisition case has been initiated, being reference made by the Deputy Commissioner Hailakandi under Section 18 of the Land Acquisition Act, on the basis of a petition filed by one Avanikanta Sinha, praying enhancement of compensation awarded to him for acquisition of land to construct approach routes to PMT beach over river Pola at village Polarpar. Now, petitioner Dominikanta Shinava filing the petition has averred that the land measuring 13 Katha 18 Shotaks appertains to Pata number so and so, covered by Dak number so and so. Your Lordship will find value 192, 152, 153 Mauja Polarpar was owned by him, and during his continuous position in assertion of his right title interest, government in referent LA case number so and so, by government notification number so and so, under section so and so, and the declaration made by notification number so and so under section 6 of the Land Acquisition Act, published in the Assam Gazette, acquired the land for the purpose of construction of approach road to PMTB over river Pola at Polarpar on Silchar Bodorpur road. It is further averred that over the part of this land there was a big fishery measuring 453 4 lakh 55,453 cubic feet of the petitioner, and on the northern bank of the fishery there were 3 numbers of Assam type shop and 6 numbers of food bearing coconut trees and about 20 numbers of banana trees, which are the main source of livelihood income of the petitioner. The collector Hailakandi by the award number so and so in LA case number so and so under section 11 of the Land Acquisition Act paid compensation to the petitioner on respect of the market value of the land and digging cost of the fishes, which the petitioner has received under protest. It is contended that while making the award, the learned collector did not comply with all the mandatory provisions of law and thus caused serious injustice to him. It is further averred that the land collector made the award without taking into consideration the present market value of the land. Shops, houses, wood-bearing trees, cost of digging the fishery, and value of the fishes, as well as thereby cause loss to future prospect of his income from property, and the award was highly unreasonable and unjustified. It is contended that at the relevant time there were around 2.5 lakhs of fishes of various types. The collector did not award interest as per provision of section 34 of the LA Act, 9% and 15% from the date of taking or possession of the acquisition land till date of making final payment. With the above, the petitioner has prayed for awarding compensation as per market value of the land. Fishery, fishes, houses, etc., and other allied benefits as per provision of section 23 to 23 IA and with interest at the rate of so. The petitioner has claimed rupees 1,35,000 towards actual market value of the land, rupees 6,83,171 towards digging cost of the fishery, and rupees 12,50,000 towards the price of the fish, etc. Total he claimed 72,48,066 as compensation with interest. Also prayed to refer the same to the court as court referred. Accordingly, Deputy Commissioner Hailakandi referred the said petition to the court under section 18 of the LA, and thus the instant miscase was registered. Notice was issued and the opposite party Deputy Commissioner Hailakandi appeared and submitted written objection and pleaded that the instant case is not maintainable in its present form and manner. There is no cause of action for filing the case, etc. Answering opposite party by submitting written statement admitted that the acquisition of land measuring so and so of the petitioner for construction of approach road CMP bridge over Pola on Silchar Bodorpur road. It is also admitted that the entire acquired land belonging to the petitioner is a part of big fishery measuring 38,565 square feet in area and 11.80 feet in depth, which the petitioner used to cultivate fish every year on seasonal basis, that is during the month of April, May to September, October. It is averred that the Assam type houses, shops, coconut trees, etc. were not affected due to the acquisition of the land. The land collector has averred that the market value of the land was determined at 34,000 per vega. That is grossly inadequate, your lordship will find in view of Exhibit 1, 2, and 3. As per provision of Section 23 of the Land Acquisition Act, and the digging cost of fishery measuring 453 cubic feet was assessed at 2,27,726 at the rate of per thousand cubic feet of the earth, and as per implied principle executive rules of government of Assam, which appears to be justified and proper. It is further averred that during joint inspection on so conducted by the subdivisional officer Hailakandi, assistant executive engineer, road construction, no fish and water was found in the said fishery. As such, assessment of valuation of the fishes as claimed by the petitioner was not made and no award was made to that effect. Since the award amount was tendered to the petitioner immediate after approval of the government, the question of awarding interest doesn't arise. It is averred that the adequate compensation amount to rupees 3,55,000 was paid to the petitioner. So petitioner, out of this 19 lakhs I have shown, he got only, my lord, 3,55,000, which includes the valuation of the land, digging cost of fishery, and also additional compensation of market value of the land and fishery under provision of Section 23 and 20% solatium for 1 year as provision of so. The petitioner received the said amount under protest. The petitioner was to get, my lord, 12 lakhs, and towards digging of fisheries 7 lakhs. 19 lakhs and odd. He got only 3 lakhs, and they says it is your demand is satisfied, you can go home. That is their stand. So this is quite contradictory to the documents, your lordship will find. The petitioner during the pendency of the case died, and as such, by total number, his legal heirs has been substituted. Petitioner side, in order to prove their case, examine Vibha Sinha as PW1, who is the son of original petitioner, and one Masaruf Ali as PW2. PW1, by adducing evidence, had reiterated the same things what has been stated in the original petition. More specifically, stated that the amount of compensation as awarded by the collector was not adequate. The price of the fishes and standing trees were not taken into consideration while determining the compensation. Further, the value of the land and the cost of digging of the fishery was not assessed properly. The PW1 has made a claim of rupees 72 lakhs 48,066. In cross-examination, he has stated that his father made the claim only in respect of damage of land and fishery. He cannot say total amount of compensation received by his father. The PW2 has stated in his evidence that on the acquired land there were 3 numbers of RCC Assam type shop houses, 7 numbers of fruit-bearing coconut trees, 220 numbers of banana trees, fisheries. The contesting opposite party did not adduce any evidence. So here we find, my lord, that besides this oral testimony of PW1 and PW2, there are 3 documents, 3 sale deeds, no mention, my lord, totally ignored. Now, if we go into this sale deeds, my lord, in the case record, your lordship will find, my lord, that the price of the land is much more than what they had calculated and what the award has been paid, your lordship. And that too, total award was not paid to the petitioner. Hard argument of learned counsel of both sides also gone through the written argument submitted by the learned counsel of the petitioner. From the pleadings as well as from the evidence of the petitioner reduced as PW1, it appears that the land measuring so-and-so owned and possessed by the original Pattadar was acquired by the government by LA case number so-and-so for construction of approved to so-and-so Silchar Budarpur Road and paid compensation of 3,55,960, which the original petitioner has received on 27/14 under protest. According to the petitioner, the value of the acquired land was not less than 2 lakhs at the relevant time. That is important, your lordship. According to the petitioner, he said it is not than 2 lakhs. He stated, my lord, less amount. Document says it is more than 3 lakhs, your lord. Learned collector has assessed it at rupees 34 per bigha. You will not get any land, my lord, 34,000 per bigha nowadays, my lord. You will not get. Now, from the written objection submitted by the opposite party, it is found that learned collector had fixed the value of the land as per provision of section 23 depicts that the value of was assessed at rupees 22,950. Though the petitioner has taken the plea that the value of the land was not less than 2 lakhs per bigha, but could not prove the same by adducing cogent evidence. That is not correct, my lord. The face of the record. There are 3 exhibits here, lord. The acquired land is situated in village area and it was acquired in the year 2004 and therefore the assessment value of land so and so was found just and very reasonable. So what they had awarded, my lord, that is reasonable. So give me 19 lakhs and odd. I claimed 72 lakhs in the reference case, my lord. Your calculation is 19,000 as per record. Now, in the hearing, you are saying not, I will be getting only 3 lakhs and odd. The digging cost of fishery measuring so and so cubic feet was assessed at 2,20,000 per 1,000 cubic feet, and it is stated by the opposite party the said assessment was made under the provisions of section so and so. Only digging cost of the, my lord, fishery is 2,27,700 as per their requirements, my lord. And I am getting 3 lakhs, my lord, including land, girat, everything, my lord. Was made under the provision of, in comparison to the area of the fishery, the digging cost of so and so per 1,000 feet is found to be very much reasonable and justified. Further, the petitioner's side could not prove that they incurred more amount of money than that was awarded in digging the fishery. The petitioner side has pleaded that in awarding the compensation, the value of the fishes was not taken into consideration. According to petitioner, 2.5 lakh fishes produced in the said fishery, and if the price of per fish is taken at rupees 5, the amount of compensation for fishes come to rupees so and so, your lordship, the 12,50,000. The opposite party admitting the existence of a big fishery awarded so and so towards cost of digging, but no compensation was awarded to the loss of fishes. My lord, this is also an admitted fact, your lord. The opposite party in their written objection has admitted that the petitioner used to cultivate fishes every year on seasonal basis, and if that be so, the petitioner would certainly be entitled to adequate compensation for loss of fishes, which would earn in the next year and so on. The opposite party in their written statement has stated that during joint inspection, no water and fish found in the fishery and as such, compensation was not awarded for the loss of fishes. The existence of fishery would certainly entitle the petitioner to cultivate fish from every year. In the written objection, the opposite party has stated in the month of March, the joint inspection was held and found no water in the fishery. The month of March in the region is a completely dry season and could not be expected that in the month of March there would be water in the fishery. From the depth of the fishery, it is assumed that during rainy season huge water would be accumulated in the fishery. Therefore, the petitioner would certainly be entitled to compensation for the fishes which are recurring income of the petitioner, but the learned collector did not take into consideration the said vital factor at the time of awarding compensation. The petitioner side has given an exorbitant calculation in respect of fishes, and therefore the said calculation is not taken into consideration. Considering the land, breadth, and depth of the fishery, the ends of justice would be made if a lump sum of rupees 1 lakh is awarded to the petitioner as compensation for the fishery. Compensation for the fishes, your lordship. So it is only 1 lakh of rupees he has enhanced. Other side, my lord, while my lord, the petitioner or the appellant is entitled to 19 lakhs, my lord, it is grossly reduced now to 3 lakhs and not 2 lakhs. Now, petitioner side further contended that there were Assam type houses, coconut trees, banana trees, etc. on the land, but no compensation was awarded for the same. The opposite party, by submitting written statement, has stated that during the land acquisition, the Assam type houses and trees were not affected. Land has been acquired, my lord. When the land is acquired for the construction of the road, then whether the trees will remain and the houses will remain, my lord, what is this? Land was acquired for the BITA for construction of a road.
Yes,
So
sir.
naturally, my lord, this will not be there now. The petitioner side, by adducing cogent evidence, failed to prove existence of houses and trees on the land, and because of acquisition of land, these were damaged. Now, the government is admitting, my lord, and Jirat compensation was also given. Later on, they had forgotten. So for that thing, my lord, petitioner cannot be held liable. It is an admitted fact that there was a fishery, there were houses, there were accordingly Jirat, my lord, 7 lakhs of rupees was awarded by the government, my lord, itself. 12 lakhs towards land and 7 lakhs towards the Jirat. Now here I find other things, my lord. Therefore, the petitioner side would not be entitled to any relief for the said houses and trees. The records reveal that the learned collector had awarded 12 solatium as so as the market value of additional compensation of land and the fishery as per provision of so. The award or collector is reproduced below. For land, your lordship, the learned district judge says it is 22,950. 1 bigha of land, my lord. More than 1 bigha, it is 20,000. And this is also incorrect with reference to, my lord, page 17 of my appellant, my lord. Then for others, that is digging fishery, my lord, 2,27,000. That is more or less correct. Now, additional compensation 75,000. That is also not correct. Solatium 30,000. And what the learned district judge is stating, my lord, total compensation which the collector has decided to pay is 3,55,959 instead of, my lord, 19 lakhs and what. So this is, my lord, if your lordship goes into, my lord, page 17, 18, 21, 22, 24, 29, 31, 32, your lordship will find that these are not correct. With reference to documents, my lord, I am submitting this. This is contradictory to what is there at page 17, 18, 21, 22, 24, 29, 31, 32 of our appeal before this honorable court. And what is the duty of the learned district judge, your lordship, is to, while determining the compensation, he is to take consideration not of this, my lord, he is to take consideration of section 23 of the Land Acquisition Act, your lordship. So without taking consideration of Exhibit 1, Exhibit 2 and Exhibit 3 in the case record, and without taking consideration of the statutory provisions of law under section 23 of the Land Acquisition Act, my lord, now the learned district judge, my lord, page 57, paragraph 13, in view of the above discussion, it is found that the petitioner be entitled to additional sum of rupees 1 lakh as enhanced compensation for the fishes with interest 9% annum on the said amount of 1 lakh as per section 28 of LA Act from the date on which the learned collector took possession of the land till the date of payment of such enhanced compensation. In fine, the case is partly allowed with award that learned collector Hailakandi shall pay rupees 1 lakh to the petitioner as enhanced compensation with interest of so said amount of rupees 1 lakh from the date on which the collector took possession of the land till the date of payment of such enhanced compensation into court. Now, what is the total compensation petitioner is getting as per the district collector's judgment, my lord? Pays 56, 3,55,959 plus 1 lakh. That is 4,55,959. Whereas, my lord, government document says he is entitled to 12 lakhs for lands and for Jirat 7 lakhs and about 19, more than 19 lakhs, your lord. So what has been done, my lord? Gross injustice has been caused to the, my lord, the present appellant. And section 23, my your lordship knows what the learned district judge while deciding such kind of petition is to take consideration your lordship knows. Firstly, my lord, section 23 says matters to be considered in determining the compensation and determining the amount.
The old LA Act, no?
My lord.
This is the old LA Act before 2013.
Land acquisition of 1894. And that is the act they have applied. because
That has been
notification
applied.
was issued in the year 2003. That's why. 13 Act did not come.
No, it was notification, yes.
The first, my lord, market value of the land. How the market value of the land is ascertained, my lord? From sale deeds of the neighboring lands, my lord. Section 23, my lord.
Yes, yes. Section 23, yes.
That, my lord, that provisions I have also, my lord, quoted in our appeal itself, your lordship will find. Section 23. So, firstly, my lord, market value of the land at the date of publication of notification.
Yes.
So 2003, date of publication of the notification and market value. How it is to be decided, my lord, determined? It is to be determined in taking consideration of the sale deeds of the neighboring lands if any sale has taken place.
The government, they have government notification also.
Amen.
Market value, they have government.
So the, my lord, present appellant exhibited 3 sale deeds, no mention of this man. Totally ignored. So, my lord, 2001, my lord, 434, my lord, Ishwar Das, James case, Ishwar Das versus Suhanla says that if the court ignores some documents, my lord, passes, my lord, a judgment, court may pass judgment, my lord, this way or that way. But if taking consideration of this, if some view is possible, my lord, then it is to be interfered with. And with ignoring, my lord, Supreme Court says ignoring of some documents or evidence, my lord, these itself are perversity, your lord. So, my lord, firstly here, my lord, the value of the land, my lord, court did not, my lord, ascertain, my lord, with reference to documents, exhibit 1, 2, and 3. And other things, my lord, also learned district judge had not done, your lord. That is my submission, your lord. And net result, if we would not have filed an application for section 18 and a reference had not been made, he would have got, my lord, 19 lakhs and order of rupees, my lord. Now, in view of this award, my lord, judgment passed by the learned district judge, he will now be getting only 4 lakhs 55,000, your lord. 3 lakhs towards the land and 1 lakh towards the. So it has been reduced, my lord. So people go, my lord, people file, my lord, application under section 18 with hope, my lord, that it would be enhanced by the court, your lordship. But here, my lord, we find that opposite things has happened, dear lord. So that is my submission, your lordship, that in passing the judgment, learned court, learned district judge did not take consideration of exhibit 1, 2, 3 sale deeds in determining first the value of the land. Now, so far as Jirat is concerned, findings of the district judge is there is no house, no trees, etc.
No house.
But for Jirat, there is a separate compensation that was calculated with the government. So, my lord, perversity has resulted. I pray, my lord, that this judgment, first by the learned court below, my lord, your lordship may be pleased to set aside this judgment. And we further pleased to direct the respondent authorities to make payment compensation in terms of, I am praying nothing more, your lordship. Your lordship may kindly see my prayer portion at page 11, your lordship. Firstly, my lord, this judgment and order dated 7/6 passed by the learned, I prayed for setting aside this.
Okay.
Because it is not based on documents. And further, my lord, my prayer is that please direct the respondent authorities to make payment of compensation in terms of the estimate dated 1/11/2014 prepared by the Land Acquisition Officer Hailakandi and Deputy Commissioner Hailakandi, then Government's Letter, my lord, 17/2006, and the amount that was sanctioned by the Government of Assam Land Revenue Department for payment of compensation, including direct compensation for acquisition of land of the appellant, and in accordance with the law, in conformity with Section 23 of the Land Acquisition Act. That is my prayer. And all this, my lord, estimate notification, these are in the case record in my appeal, my lord, and close with my action. And with this, I conclude.
Lordship, I pray for some time, Lordship, so.
You want to obtain instructions?
Yes, Lord.
Payment can be made according to the estimate?
Yes.
There's already an estimate relating to this case.
Yes, Lordship, I have to take some instruction. Lordship.
2 days?
Not 2 days, Lordship, this is from Hailakandi, Lordship. After
Okay.
1 week, Lordship.
After 1 week?
Yes, Lordship.
After 1 week?
All right.
Yes, after 1 week.
Some of my junior will be there.
This was the estimate submitted by the ADC.
Huh?
You have annexed an estimate, no?
Yes, Lordship.
Estimate case. Estimate, my lord.
Only
Estimate
type
was
of fields.
prepared by the land acquisition officer in conjunction with the deputy commissioner.
Okay.
And I am saying that I have no mind now to go to the district judge again or this. Whatever you have calculated, give me this.
Yes, yes.
Yes, sir. Only, Lordship, in page 15, I have only type copy of this page number 2, Lordship. Page number 14 is not available with me.
ঠিক আছে, ঠিক আছে, প্রভুকে দিব। My lord, reference, my lord, at the cost of repetition, my lord, I am saying. People make, my lord, when they are aggrieved and they say the estimates or the award passed by the collector is less. So let me go to the district judge.
Yes, I know.
Now, my lord, with the hope that it would be enhanced,
Yes, yes,
taking in
yes.
consideration of the
Yes, yes.
surrounding situation.
But
And
Lordship,
quite opposite things has happened, dear lord.
Yes, yes.
and Lordship, joint inspection, Lordship, there is nothing, in the fees or Lordship, others, Lordship, in as part of the inspection report, Lordship. So that is also relevant, Lordship. There is a no fish, Lordship. And there is no water in the fishery also.
Yes, yes.
No, that's
Okay, you'll place a submission or you'll obtain instructions?
Instruction, Lordship.
Instruction, okay.
Good down.
But learned counsel, you are from
Sir, I
Delhi,
am Andhor, your lord.
Mr. Endor, no?
Yes.
For the appellant and learned government advocate,
I'm additional senior government advocate, Lordship, Didi Burman.
additional senior government advocate,
Yes.
Miss
Didi Burman,
Didi Burma
Yes.
for the respondents. Full stop.
1 and 2.
The learned counsel for the appellant has submitted his argument. The learned additional senior government advocate has submitted that he may obtain instructions relating to the estimate. All right. Relating to the estimate prepared by whom? Relating to the estimate of compensation to be paid to the appellant. And also to place a submission on the next day. List the matter on 22nd.
22nd.
Okay. Okay, 22nd May. It will রাখি থৈ দিবচোন argument.
22nd or 27th. 27th.
27th?
Yes.
The part hard koi thoi diu niki? Part hard argument koi thoi dia. I will keep it as part hard. I will dispose it.
Yes. Ablag.
May it please your lordship. This is an MSc appeal, ma'am. Appeal by insurance company.
এইটো লগতে ৰাখি থৈ দিলে ভাল হ'ব নেকি? Yes.
My lord, by this appeal, my lord, we are challenging the judgment dated, my lord, 10/1/2020, passed in MSc case number 1592/16. My lord, first of all, by this judgment, my lord, 10/1/2020, two MSc cases were disposed of.
You are a insurer or claimant?
I'm insurance company.
I'm for the owner.
Two MSc cases were disposed of. One is 1591/2016 and one is 1592/2016. My lord, we are challenging the judgment passed in 1592/16.
1592/16.
Not 1591, because 1591 was dismissed by the learned member and decided in our favor, my lord. 1592/16. My lord, basically my ground in the appeal, my lord, is the determination of liability, because the claimant has filed the MSc case against the owner, driver, and the insurance company. The liability was saddled with the insurance company, my lord, because there was a defense evidence laid by us. That evidence was discarded by the learned member and the liability was shifted upon us. So that is now the question before your lordship is to decide who is going to pay the compensation in this factual aspect, my lord. Straightway, my lord, I will read the relevant portion. Lordship may kindly see page number 15 of the memo of appeal. The internal page number 7 of the judgment.
Yes.
Paragraph 25. Now the question is, who is liable to pay the compensation to the claimants? The claimant has adduced evidence of one witness, namely, in fact, it should have been OP number 3, my lord. The claimant has adduced evidence of one witness, namely Binod Kumar Prasad, the legal manager of the insurance company, as DW1, who has deposed in his evidence that the claimant during her cross-examination has admitted that at the time of accident, the driver had possessed a learner license. As such, there was violation of condition of the insurance policy. He has exhibited the copy of the identity card, Fight Exhibit A, and copy of the insurance policy, Fight Exhibit B. I have gone through the evidence adduced by the DW1 and documents available on record and found that at the time of accident, the driver of the offending vehicle possessed a learner license, but there is no record to show as to whether he was driving without a proper driving license holder sitting beside him. Therefore, it is held that there was no breach of policy condition, and as such, the insurance company is liable to indemnify the owner of the offending vehicle. Basically, my lord, the facts, the ground here, my lord, the insured vehicle was driven by a person who was having a learner license. So that fact has been brought before the learned member MSCT, my lord. Now, learned member MSCT had discarded the evidence on the ground that we could not prove that this person was not accompanied by a person having a valid driving license. Now, my lord, lordship will see in the entire proceeding, my lord, because that evidence was laid not against the claim of the claimant, that evidence was laid against the owner of the vehicle, that is the person in respect of whom the policy of insurance was issued to by us. Now, lordship, the OP number 2, Damayanti Tea Industries, that the vehicle stands in their name only. They remained ex parte. The case proceeded ex parte against them, and they did not participate in the proceeding before MSC. Now, my lord, lordship may kindly see section 3 of the Motor Vehicle Act as regards the driving license.
This is an MB account. This will be the old act, no?
Old act. Because the case was
Purna act from the motor vehicle act. Oh, thank you. Central motor rules or nothing.
Lordship may also take up the new one also, because there is no change in that
Okay,
particular
new
section.
upon নতুন দিলে হৈ যাব কালি মই লৈ গৈছিল নেকি ভিতৰত
Lordship. এখন তেতিয়া good. Hello.
Section 3, ladies.
Okay. Yes.
Section 3, my lord. Lordship perhaps got it.
Yes, yes.
Necessity for driving license.
Yes.
No person shall drive a motor vehicle in any public place unless
Purna
he
এখনো লাগিব রে Purna দিব লাগিব লাইব্রেরি মোক লাগিব কারণ ম্যাক্সিমাম কেসবুক পুরোটা মতে আছে Yes.
no person shall drive a motor vehicle in any public place unless he holds an effective driving license issued to him authorizing him to drive the vehicle, and no person shall so drive a transport vehicle other than a motor car, motorcycle hired for his own use or rented under any scheme made under subsection 2 of section 75 unless his driving license specifically entitles him to do so. Section 3, my lord, mandates that the person driving a motorcycle should have a valid driving license. Now, my lord, lordship may kindly see again section 5. This is the responsibility, that is the duty cast upon the owner of the vehicle. Responsibility of the owners of motor vehicles for contravention of the section 3 and 4. No owner or person in charge of a motor vehicle shall cause or permit any person who does not satisfy the provisions of section 3 or section 4 to drive the vehicle. That is, the duty is cast upon the owner of the vehicle to see that section 3 is complied with while driving, while allowing a person to drive a motor vehicle in any public place. Lordship may again see section 7. Restriction on granting of learner's license for certain vehicles. No person shall be granted a learner license to drive a transport vehicle unless he has held a driving license to drive a light motor vehicle for at least 1 year. Provided that nothing contained in this subsection shall apply to an e-cart or e-rickshaw. No person under the age of 18 years shall be granted a learner license to drive a motor vehicle without gear except the consent in writing of the person having the care of the person desiring the learner license. Now, Lordship has seen that the learner license, that section 5, that there is duty upon the owner of the vehicle to see that section 3 is complied with. Now, my lord, I will place the rule 3 of Central Motor Vehicle Rules. If may kindly see. Lordship, I have got the extract of the rule, my lord.
I have. Central Motor Vehicle Routes, I have.
Yes.
Rule 3, no?
Rule 3. Licensing of drivers of motor vehicles.
Yes.
Yes. General, the provisions of subsection 1 of section 3 shall not apply to a person while receiving instructions or granting experience or gaining experience in driving with the object of presenting himself for a test of competence to drive, so long as A, such person is the holder of an effective learner's license issued to him in Form 3 to drive the vehicle. Such person is accompanied by it is important, my lord, such person is accompanied by an instructor holding an effective driving license to drive the vehicle, and such instructor is sitting in such a position to control or stop the vehicle. Number 3, C, there is painted in the front and the rear or the vehicle or on a plate or card affixed to the front and rear, the letter L in red or on a white background as under. Basically, B is important, clause B, that he has to be instructed by has to be accompanied by a person having valid driving license. Now, Lordship, now the question comes up that whether it is the burden of the insurance company to prove that that person was accompanied by a person having a valid driving license, or it is a burden of the owner of the vehicle that section 3 and section 5 is complied with by the owner of the vehicle. So for that, Lordship, I would like to place one judgment. We have seen that he has to be accompanied by a person having valid driving license. My lord, this is a judgment pronounced by Madras High Court, my lord. Lordship may kindly see para 19, page 6. Lord, this is an appeal filed by the owner of the vehicle before the Honorable High Court of Madras, challenging the pay and recovery order passed by the learned member MSCT.
Hmm.
I would read, my lord, I would read the
Yes, yes.
relevant para, and para 19.
Para 19, no?
Para 19. The relevant portion. my lord.
Okay.
Likewise, the learned counsel for the second respondent insurance company relied upon the ruling reported in CDJ so and so so and so. Here, the appellant who is the owner cum rider was not having a driving license and he was having only a learner license. Going by Rule 3B of the rules, holder of an effective driving learner's license while receiving instructions or gaining experience in driving with the object of presenting himself for a test for competence to drive has to satisfy all other conditions specified thereunder, including the requirement to be accompanied by an instructor holding an effective driving license to drive the vehicle, and such instructor sitting in such a position to control or stop the vehicle. The purpose of relaxation of rigor of Section 3(1) of the MV Act as per Rule 3(2) is only for the aforesaid purposes. There can be no doubt that the purpose of granting a driving license is to authorize the person concerned to drive the class of vehicle concerned in public place, in contradistinction to the purpose of authorizing a holder of learner license to drive the motor vehicle as a learner. In the contextual situation, some relevant aspects are worthy to be considered. Driving stroke riding a motor vehicle on any public place may cause fatal accidents or bodily injury to both pedestrians and passengers inside the vehicle or other vehicles coming in its way. Hence, a certain degree of expertise is required to drive a motor vehicle of any class or to ride a motor vehicle. If the insured fails to discharge the statutory liability under Section 5 of the MB Act, it should visit him with all inevitable consequences. In this context, in this case, the insured owner himself violated all the aforesaid relevant statutory provisions, though in the light of conditions in Exhibit B, one certificate of insurance, as also the conditions in Exhibit B, the learner license, the learner's certificate, he was also to scrupulously follow the provisions of Rule 3 of the rules. In such circumstances, it can be safely concluded that the appellant had violated the conditions of the policy as also the conditions specifically incorporated in Exhibit B2 learner driving license, besides violating the provisions under the rules as also the MB Act as mentioned above. Above all, in this case, the categoric finding of the tribunal is to the effect that the claimant who was a pedestrian was knocked down, or in other words, the accident was caused solely due to negligence of the appellant in riding the motor vehicle, and as noticed herein above, he rode the vehicle on that crucial day on the strength of a learner license issued hardly 10 days ago. In such circumstances, it can be stated that the respondent herein, the insurer, has succeeded in establishing that the appellant herein, who was the owner cum driver of the offending vehicle, had violated not only the conditions of the policy but also conditions in the learner's driving license, on the strength of which he has driven the vehicle at the time of accident.
I've read it.
Yes, madam. Again,
So,
Lordship,
that insurance will pay the amount and you'll recover from the owner.
that is the law, my lord, in respect of learner license. Because, my lord, I'm again, Lordship, I'm relying upon the judgment of Honorable Apex Court, my lord.
Yes.
Yes, my lord.
Hmm.
Because here, my lord, the position is clear whether what is the duty of the owner of the vehicle
Hmm.
as regards the driving license and what he should have brought before the learned member, my lord.
Hmm.
Lordship may kindly see paragraph 14.
There are 14 years.
Yes, my lord. I'm sorry, my lord. Paragraph 11, my lord. Paragraph 11.
Okay.
The question is whether the fact that the offending vehicle bearing number so-and-so was duly insured by respondent number 2 insurance company would per se make the insurance company liable. This court, in the case of National Insurance Company Limited, has noticed that defense available to the insurance company under section 149(2)(a) Roman 2 of the Motor Vehicles Act 1988. The insurance company is entitled to take a defense that the offending vehicle was driven by an unauthorized person or the person driving the vehicle did not have a valid driving license. The onus would shift on the insurance company only after the owner of the offending vehicle pleads and proves that the basic facts within his knowledge that the driver of the offending vehicle was authorized by him to drive the vehicle and was having a valid driving license at the time of accident. Now, my lord, it becomes clear that it was the duty of the owner of the vehicle to see that the person who is sitting on the wheels had a valid driving license, rather than the burden of the insurance company to show that this person was accompanied by a person having valid driving license. In the present case, the respondent number 1, owner of the offending vehicle, merely raised a vague plea in the written statement that the offending vehicle so-and-so was being driven by a person having valid driving license. He did not disclose the name of the driver and his other details. Besides, the respondent number 1 did not enter the witness box or examine any witness in support of the plea. The respondent number 2 insurance company in the written statement has plainly refuted that plea and also asserted that the offending vehicle was not driven by an authorized person and having valid driving license. The respondent number 1, owner of the vehicle, did not produce any evidence except a driving license of one Joginder Singh without any specific stand taken in the pleadings or in the evidence that the same Joginder Singh was in fact authorized to drive the vehicle in question at the relevant time. This is the factual matrix of that particular case. In our case, my lord, the owner of the vehicle remained absent all along in the proceeding. In fact, the case proceeded against ex parte against them. So there was no rebuttal evidence to the evidence laid by the insurance company, and it was established that vehicle was
having a learner's
learner license, and he was not accompanied by any person having valid driving license as per the requirement of Rule 3B of the Central Motor Vehicle Rules, emanated from Section 3(1) of the MB Act.
Yes.
This is my submission.
Okay. Okay, I am for the owner of the vehicle. If this appeal here, the insurance company tried to shift it,
Please take place a speaker on your mouth. Yes.
shifted the burden
Hmm.
to the owner. Lordship, in this judgment, impugned judgment, the learned court below already observed and held that in para 26, page 15
Hmm.
of the appeal memo. Para 15, page 15, para 26.
Okay. Hmm.
That I've gone through the evidence adduced by the DW1 and documents available on record and found that at the time of accident, the driver of the offending vehicle possessed a learner driving license
but there is a no record to show as the whether he was driving without a proper driving license holder sitting beside him. Okay. At that time, the driver have a learner license. Lordship, in this regard, Lordship, the driving license, the learner license is valid license or not, whether it is a duly licensed or not. In this regard, the apex court held it in Saran Singh case. I place one judgment, Lordship. There are 35, Lordship. Internal page 1545. One five four five, para 35.
Yes.
May I read, Lordship? Para 35. It is beyond any doubt or dispute that under section 149(2) of the Act, an insurer to whom notice of the bringing of any proceeding for compensation has been given can defend the action on any of the grounds mentioned therein. However, clause A opens with the words that there has been a breach of a specific condition of policy, implying that the insurer defends the action would defend upon the terms of the policy. The said subclause contains 3 conditions of disjunctive character, namely the insurer can get away from the liability when A named person drives the vehicle, B, it was driving by a person who did not have a duly granted license. A specific word here, duly granted license. And C, driver has a person disqualified for holding or obtaining a driving license. Next paragraph, Lordship. We may also take note of the fact that whereas in section 3 of the word used as effective license, it has been differently worded as section 149(2), that is duly licensed. If a person does not hold an effective license as on date of the accident, he may be liable for prosecution in terms of section 141 of the Act, but section 149 pertains to insurance as regard third-party risks. Duly licensed and Lordship, duly granted license and effective license. I have a learner license at that time, not a driver. Lordship. Next, come to Lordship, para 105. Page, internal page 1557. The second last page, Lordship.
Para 105. Okay. All right.
May I read, Lordship? The summary of our findings to the various issues as raised in this petition are as follows. Number 1, Chapter 11 of the Motor Vehicle Act 1988 providing compulsory insurance of vehicles against third-party risks in a social welfare legislation to extend relief by compensation to the victim of accident caused by use of motor vehicles. The provision of compulsory insurance coverage of all vehicles are with this paramount object, and the provision of the Act have to be so interpreted as to effectuate the said object. Insurer is entitled to raise a defense in a claim petition filed under section 63A or section 166 of the Motor Vehicle Act 1988, inter alia in terms of section 149(2)A Roman 2 of the said Act. The breach of policy condition, there is disqualification of driver or invalid driving license of a driver as contained in subsection 2A2 of section 149 have to be proved to have been committed by the insurer for avoiding liability by the insurer. Mere absence, fake or invalid driving license or disqualification of the driver of a driving at the relevant time are not in themselves defense available to the insurer against either to the insurer or the third party. To avoid its liability towards insured, the insurer has to prove that the insured was guilty of negligence and failed to exercise reasonable care in the matter of fulfillment of the condition of the policy regarding use of vehicle by duly licensed driver or one who was not disqualified to drive at the relevant time. Lordship, now, Lordship, Roman 8, Lordship, below Roman 8.
Yes.
If a vehicle at the time of accident was driving by a person having a learner license, the insurance companies would be liable to satisfy the decree. In another judgment, Lordship,
Oh.
Lordship,
It is okay.
Lordship, in this judgment also, Lordship, the Supreme Court held that the para 7, Lordship, first, para 7, 5547, page number.
Okay.
May I read, Lordship?
Yes.
As regards the contention that the driver of the vehicle was not duly licensed as he possessed a fake license, it may be noted neither section 149(2)(a)(2) of the Act of 1988 nor the driver clause in the subject insurance policy provided that the owner of the insured vehicle must, as a rule, get the driving license of the person employed as a driver for the said vehicle verified and checked with the concerned transport authority. Generally, and as a matter of the course, no person employing a driver would undertake such a verification exercise and would be satisfied with the production of a license issued by the similarly competent authority, its validity of which has not expired. It would be wholly implicated for every person employing a driver to expect the transport authority concerned to verify and confirm whether the driving license produced by the driver is a valid, genuine one, subject to just exceptions. In fact, no such mandatory condition is provided in any car insurance policy, and it is not open to the petitioner in insurance company, which also did not prescribe such a strange condition to cite the failure of the deceased vehicle owner to get Ujjal Pal's driving license checked with their RTO as a reason to disclaim liability under the insurance policy. These judgments regarding the valid license or a fake license, in fact of the case, the insurance company claimed that the driving license of the driver is a fake one.
Learner's license.
Not here is the driving license. Lordship, now para 15, the findings in this judgment, Lordship.
Okay.
The second last page, Lordship. Internal page 5550. Para 15, may I read? As already pointed out, Chopra, once a seemingly valid license is produced by a person employed to drive a vehicle, unless such license is actually a fake one on the face of it, warranting any sensible employer to make inquiry as to its genuineness, or when the period of the license has already expired, or there is some other reasons to entertain a genuine doubt as to its validity, the burden is upon the insurance company to prove that there is a failure on the part of the vehicle owner in carrying out due diligence sans driving license before employing that person to drive the vehicle. Presently, no evidence has been placed on record where any inference could be drawn that the deceased vehicle owner ought to have gotten verified the Ujjal Pal's driving license. Therefore, it was for the petitioner insurance company to prove willful breach on the part of the said vehicle
This
owner.
is not similar to your case. This is fake driving license.
Lordship, that's
Learner's license is not fake.
not fake, Lordship.
This is not similar to your case.
Lordship, at the end, Lordship, already the learned court below, it is held that that driver at the time of accident have a learner driving license, and it is no record to show as the whether he was driving without a proper driving license.
A small response, my lord.
Okay.
Lordship, my submission is that I'm not submitting that the learner license is not a valid driving license. It's a valid driving license, my lord. Only the condition is that he has to be accompanied by a person having valid driving license, because he's being ready, he's been being made ready for any test for having valid driving license, because for having valid driving license, he has to undergo a test. Lordship, my friend has relied upon the judgment of Saran Singh's judgment. That is a very important judgment, my lord. Lordship, may kindly see now para 88 of the judgment. That is specifically about learner license. Because we are not denying that learner license is not a valid driving license. Section para 88, my lord. Page number 1555.
Yes.
Yes. Motor Vehicle Act 1988 provides for grant of learner license. See section 4372, section 10.3 and section 14. A learner license is thus also a license within the meaning of the provisions of the said act. It cannot therefore be said that a vehicle, when being driven by a learner, subject to the conditions mentioned in the license, he would not be a person who is not duly licensed, resulting in conferring a right on the insurer to avoid the claim of the third party. It cannot be said that a person holding a learner's license is not entitled to drive the vehicle. Even if there exists a condition in the contract of insurance that the vehicle cannot be driven by a person holding learner license, the same would run counter to the provisions of section 149(2) of the said act, rightly submitted by my learned friend, my lord. My point is on the aspect, my lord. Lordship will see, my lord, para 89. The provisions contained in the said act provides also for grant of driving license which is otherwise a learner license. Section 3(2) and 6 of the said act provides for restriction in the manner of grant of driving license. Section 7 deals with the such restrictions on granting of learner's license. Section 8 and 9 provide for the manner and the conditions for grant of driving license. Section 15 provides for renewal of driving license. Learner's license are granted under the rules framed by the central government or the state government in exercise of their rule-making power. Conditions are attached to the learner's license. Learner's licenses granted in terms of the statute. A person holding a learner's license would thus also come within the purview of duly licensed. As such, a license is also granted in terms of the provisions of the act and rules framed thereunder. Because he has to obey the rules, my lord. To be treated as a duly licensed, he has to obey the rules, motor vehicle rules. That is what has been said by the apex court in this judgment, my lord. It is now a well-settled principle of law that the rules validly framed become part of the statute. Such rules are therefore required to be read as a part of the main enactment. It is also a well-settled principle of law that for the interpretation of the statute, an attempt must be made to give effect to all the provisions under the rule. No provision should be considered as surpluses, because rules emanates from the act, my lord.
Yes.
To be treated as a duly licensed, I'm repeating, my lord, he has to follow the rules. The rules have come out from the section 3 of the MB Act, my lord. 3B, rule 3B, that he has to be accompanied by a person having valid driving license. That is not done, because that is not done, and there is no proof by the owner that has been complied with, because the case proceeded expertly against them. They did not participate in the proceeding. There is no counter evidence.
Lordship, in their appeal memo, Lordship, page 3, para 3, they stated that, may I read para 3?
Yes.
That the appellant as opposite party number 1 is in difference to the notice issued by the learned tribunal entered appearance contested the MSC case numbers by way of filing written statement with a specific field that the vehicle number so and so was permitted to be driven by a person having no valid an effective driving license, which amounted to breach of condition. Now my learned friend said that it's a valid license, but it's a learner license. And already the learned court below also observed and held that my license, the driver license is a valid license, and it's a learner license and accompanied by a.
My lord, I am not disputing that this is not a valid license. This is a valid license, but only the rule is not followed.
But in their appeal, they said that it's
To be
not a
treated as
valid
a
license.
to be treated as a duly license. Valid license and duly license, two different terminologies, my lord.
I am in the claimant number 1 and 2 in this appeal. But in this case, learned tribunal passed the judgment rightly. So now the appellant filed this appeal with a contention that the owner should pay the compensation amount as per his submission. Then, in this case, owner also represented before this honorable court. He stated that the driver possessed the learned license with a valid license. So insurance company is liable. So in this case, I have nothing to say. In this case, they have to fighting each other, and lawsuit has to pass the judgment accordingly.
You
That is
driver.
no. I am for the claimants number
Claimant.
1 and 2,
Yes,
the
yes.
mother and sister of the disease.
Okay, okay.
Highly obliged, Your Honor.
Our learned counsel, Mr. T. Kolga. For the appellant, learned counsel, Mr. N. Debnath.
Yes, Lordship.
For the respondent
Number 1 and 2.
and learned counsel, Mr. J. P. Moore. For the respondent number 3, reserved for judgment and order.
Highly obliged, Your Honor.
Much please.
Wait, please, your lordship. Lordship, I have a request regarding item number 25.
Okay.
Lordship, I am for the respondent. Lordship, we have filed an affidavit in objection, but for some reason today in the court's record, we could not find it. We have confirmed it with the appellant also. They also have the copy of the said objection. Lordship, may kindly allow us to furnish that particular copy by way of requisition. Presently, we are filing it.
You want the copy to be here?
Yes, Lordship, in the court record.
Okay, it will come. Let's try.
Deeply obliged, Lordship.
In the afternoon.
Yes, Lordship, in
Okay.
the afternoon. It's the last item, Lordship.
Long pending case. It will remain as it is.
Deeply obliged.
Obliged, Your Honor.
Item number 28, fixed at 2 p.m. for hearing.
May I please, your lordship? Lordship, this second appeal is preferred against concurrent finding. Your Honor, I take your, Your Honor.
What about the other side? You are not going to respond? Yes, yes.
Your Honor, Your Honor, the substantial questions of law, there I take your lordship to page 14. There are 4 substantial questions of law were proposed. And thereafter the Honorable Court, by order dated 5/6/2024, Honorable Court by order dated 5/6/2024 proposed 2 substantial question of law. With it, the Honorable Court has also stated that if required at the time of hearing, more substantial question of law can be framed. Your Honor, for a second, I take your lordship to page 45, the plain. Page 45, the plain. Enclosure 3, page 45, it is a type copy. You know the claim. I come to the claim portion. Petition filed for recovering amount of rupees 7,55,450 due from the defendant. The plaintiff has filed for recovery of the amount, and the details of that recovery is stated at paragraph number 8. I take your lordship to page 51 of, I'll read the vernacular at page 8 of page 51.
This appeal, who has passed the judgment? Civil Judge Senior Division.
Senior Division has passed the appellate court, and the Junior Division.
Okay, no, because it has come from Lakhimpur Region.
Yes.
Because I have also passed so many judgments, that's why I'm checking.
No, Yona, this is against, Yona was not a part, has not executed. I think the claim of the plaintiff was for recovery of 7,55,450. So from very initial 7,55,450 was the claim amount, the distribution of which I like to read the vernacular at page 51 at paragraph number 8. Badir 51, may I page 51, para number 8. বাদীৰ বিবাদীৰ প্ৰতি যথেষ্ট আন্তৰিকতা মৰম ও বিশ্বাস আছিল সেয়ে যোৱা ইংৰাজী মেবি প্লিজ 4/7/2014 4/7/2014 তাৰিখে বিবাদীৰ টকা প্ৰয়োজন হোৱাত সেইদিনা বিবাদী বাদীৰ ঘৰলৈ আহে আৰু বাদীক 1 লাখ টকা ধাৰলৈ দিবলৈ খাটনি ধৰে বাদীয়েও উপায় নাপাই পকী ঘৰ বনাবলৈ বুলি গোটাই থোৱা টকা নগদ 1 লাখ টকা দিবলৈ ৰাজি হয় বিবাদীয়ে বাদীক অনুৰোধ কৰি কয় যে the first was 4/7/2014 it was 1 lakh বিবাদীয়ে বাদীক অনুৰোধ কৰি কয় যে মোক যেনে তেনে টকা কেইটা দি সহায় কৰা যিহেতু মই আগতেও বিভিন্ন সময়ত তোমাৰ পৰা সাক্ষীৰ সাক্ষাতত টকা লৈ আজিলৈকে আৰ্থিকভাৱে সহায় কৰি আহিছো ইয়াৰ ওপৰত ভিত্তি কৰি সাক্ষীৰ সাক্ষাতত সেইদিনাই এখন চুক্তি পত্ৰ বিবাদীয়ে বাদীক দিব লগা যোৱা ইংৰাজীত 2/2/2014 তাৰিখত লোৱা 3 লাখ টকা 11/5/2014 তাৰিখে লোৱা 3,55,450 টকা আৰু আজি ইংৰাজী 4/7/2014 তাৰিখে লোৱা 1 লাখ টকা মুঠ 7,55,450 টকা একেলগে ঘূৰাই দিম বুলি সাক্ষীগণৰ সাক্ষাতত স্বাক্ষৰ গ্ৰহণ কৰি চুক্তিপত্ৰত নিজে চহী কৰি এখন চুক্তিপত্ৰ সম্পাদন কৰে আৰু উক্ত মুঠ ধাৰে লোৱা টকা সেই ধাৰে লোৱা তাৰিখৰ পৰা এবছৰৰ ভিতৰত ঘূৰাই দিম বুলি চুক্তিপত্ৰত লিখিতভাৱে প্ৰতিশ্ৰুতি দিয়ে প্ৰদৰ্শক এক চুক্তিপত্ৰ so your honor 4/7/2014 1 lakh 2/2/2014 3 lakh and 11/5/2014 3,55,450 it comes to 7,55,450 on 3 subsequent days and I take your lordship now page 143 I would like to 143 I would like to read the vernacular at page 144 This document, before going into the depth of the document, your honor may be pleased to see second paragraph, Aru. There are 2 inks. 144. In the second paragraph from Aru, there are 2 inks. And with regard to that, FSL was also conducted. FSL examining officer has also come. The scientific officer has also stated and gave opinion that 2 documents were the document at exhibit A1 at page 144. It comprises of 2 writings at 2 different instances. So in this writing, may I be pleased to read? Moi Srimoti Nilu Gogoi Gaon Setia Gaon Uttor Lakhimpur Jila Lakhimpur Akham Ward number 5 Mur Tokar Bikhesh Proyojon Hoat Lilabari Kaligaon Nidwashi Srimoti Lokhima Dottor Pora Nogot 1 lakh toka dhar হিচাপে ললো উক্ত টকা মই একে বছৰৰ ভিতৰত ঘূৰাই দিম বুলি লিখিত প্ৰতিশ্ৰুতি দিলো this ends here then it continues আৰু মই যোৱা ইংৰাজী যোৱা 2/2/2014 আৰু 11/5/2014 তাৰিখে লোৱা ক্ৰমেকৈ 3 লাখ টকা আৰু 3,55,450 টকা মুঠ 7,55,450 টকা একেলগে আজিৰ পৰা এবছৰৰ ভিতৰত ঘূৰাই দিম বুলি লক্ষীমা দত্তক স্বামী শ্ৰী ৰাতুল শইকীয়াক দিম বুলি লিখিত প্ৰতিশ্ৰুতি দিলো there are 3 witnesses here so your honor this document was the document exhibited by plaintiff this document and the claim of the defendant is that yes it is admitted that 1 lakh I have to return to Lokhima Dotto. But with regard to the other variation of 3 lakh taken on 2/2/2014 and 3,55,450 taken on 11/5/2014 is completely denied. And to prove the content of this document, initially FSL was prayed for. The scientific officer has come before the honorable court as court witness and has come before the honorable court at page number 140 and stated and gave opinion that yes 2 inks are used from Aru and the subsequent parties written subsequently with a different ink. The plaintiff to prove his contents has the plaintiff on his own as PW1, the husband of the plaintiff as PW2 who are and other 2 witnesses who are the attesting witnesses of the document are PW3 and 4. So, you know, I take your lordship in PW1 as witness, I take your lordship to evidence of PW1 60 3. It starts from 63 to 63, where it was same with the money suit. I will take only to the cross part, for the cross part at page 67.
Okay.
The defendant Nilu Gogoi through Exhibit 1 has done agreement with me. I have not signed in Exhibit 1 as party in the agreement is not done with Nilu Gogoi. Page 67. The relief that I have claimed on amount of rupees 7,55,450 is based on 2 rupees revenue ticket. I have not affixed the amount of stamp as required while doing the Exhibit 1. I have not registered the Exhibit 1 at the register office after affix of the statement. I'll take lordship to the relevant portion at page 68 because this is the technical questions. Witness Ratul Soikia, Riju Soikia and Senimai Soikia was present when the defendant took rupees 3,55,450 from me. It is a full stop and O will be capital. On 2/2/2014, the defendant took money of rupees 3 lakhs at around 2:33. At the time of taking the money, my 3 witnesses were present. The witness Ratul Soikia is my husband. Witness Riju Soikia is near one of my village and witness Senimai Soikia is also from my village. I have brother and sister relations with them. So more or less, they are
Siblings.
Siblings. Or can be stated husband and cousins. Then I take your lordship to relevant portions I'm reading. 69. 69. The first paragraph. I went to the defendant's house. This is my... I went to the defendant's house demanding the money several times. And I took Rina Dotto along with me every time. I have not made Rina Dotto as a witness. Next, I file income tax return. She is a A&M nurse, my lord. She's a government employee. I file income tax every year as I being a government employee. In the year 2014, at the time of submitting the income tax return, I have not shown the amount 7,55,450 given to Nilu Gogoi on credit. And I take another relevant portion is at page 70, the last paragraph. So here I wanted to show by these two at page 69 is that Rina Dotto was a witness with whom she went every time to the defendant's house. She was not made a party. Other 3 witnesses are husband and cousin. And with regard to the income tax, as to more than 20,000 is not permissible, she has filed 7,55,450 on cash. And on the query, on cross-examination, she has stated that yes, I file income tax, but that has not been stated. I take lordship to page 70, the last paragraph. I have not taken any papers in writing for the defendant while giving the amount 3 lakhs on 2/2/2014 and the amount of rupees 3,55,000 on Iman to the defendant. So this is the evidence of PW1 who was the plaintiff. I take your lordship to PW2 at page I take your lordship to the cross, page 88. Ratul Soikia is the husband and he has admitted that he was the person who has written the document that I have shown before your lordship. The plaintiff went to the house of the defendant several times and every time went alone. This was in his evidence. In his evidence, he has clearly stated that he has went several times with the plaintiff to the house of the respondent. On cross-examination, he has stated the plaintiff went to the house of the defendant several times and every time went alone. And the plaintiff never even met once the defendant. I never went to the house of the defendant to demand money along with the plaintiff. I signed in my written deposition after reading, and I have stated in deposition that I went with my wife, that is the plaintiff, to the house of the defendant. Exhibit, it is not true that as I have given false deposition, so there is a mismatch in the written deposition and today's deposition. Exhibit 1, whole statement is written by me. Exhibit 1 is the document that Your Honor I have shown. Is written by me. It is not true that in the exhibit 1 from first line to till half portion 11 number line and from half portion of 11 number line to till 19 number line is written at different time with me and with different pen. It is not true that on 4/7/2014 the defendant Nilu Gogoi, after taking the 1 lakh rupees signing the exhibit 1, after living in the exhibit 1 from the 11 number line to the 19 number line, I fabricated by writing in the exhibit 1. The word prostitute has been written twice by me. The amount which is mentioned in the exhibit 1 from the 11 number line to 19 number line, that is amount is entered later. My lord, there is a typographical error later. In vernacular, it is
No,
since.
but it's okay.
Yeah,
These facts are there.
Facts
but
are there, yes,
we'll-
Your Honor.
we'll
So
leave
he
the
has
questions of
admitted,
law
he has firstly stated that he has not written the other part because 1 lakh is admitted. I also admit 1 lakh. With regard to the other line, there are no admission. Thereafter comes the evidence of PW 3 and 4 on the basis the Honorable Court, while passing the decree before proceeding, Your Honor, substantial initially draft issues were framed, thereafter issues were framed. Amongst those issues, one issue was that, Your Honor, for a better enclosure, page 60, Your Honor, for a second. Page 60. Page 60. Your Honor, these were the draft issues submitted, and thereafter the issues were framed at, I take your losses to 61A, the next page, 61A.
Yes.
There were 4 issues framed. And amongst the 4 issues, the first was whether there is cause of action. Second, whether the defendant borrowed an amount of rupees 3 lakhs on 3,55,000 on 11 and 1 lakh on 4/7/2014 from the plaintiff. Third was the most important, whether the alleged agreement between the plaintiff and the defendant is a valid agreement in the eyes of law. This was struck down by an order dated just prior to the passing of the judgment. The judgment was fixed on 10/12/2020 and 26/11/2020. It was struck down at enclosure 7. Parties are represented by the learned counsel. While perusing the case record for preparing the judgment, it is found that the issue number 3, framed by the learned Pradesh of White, order dated 25/1/2016, regarding validity of the agreement between the plaintiff and the defendant, is not relevant material for deciding this suit. It is to be noted that though in the plain it is stated that on 2/2/2014 the defendant entered into an agreement, from the said agreement dated 2/2/2014, it is seen that it is a hand note, money received only, and not an agreement as pleaded by the plaintiff. And so the vital issue on which FSL was conducted, the scientific officer came and gave evidence. Even the learned trial court as well as the appellate court, while passing the judgment, has discussed with regard to that hand note, stating that it is not an agreement, it's a hand note. But the important was that it was struck off. And striking off the issue has prejudiced the right of the defendant because it was on the basis of that hand note the case proceeded. It was the plaintiff's document. Plaintiff has annexed that document. It was the plaintiff's statement in its evidence in chief that this was the document signed in front of the witness number PW 2, 3, and 4, that this document was made. And later on the day prior to the passing of the judgment, it was struck off. The Honorable Court may be pleased, and the Honorable Court in many cases have seen that when issues are struck off, the court frames reissue, new issue on ground. If the issue is not at all discussed during whole trial, it can be discarded. But when FSL was conducted, officer was called for, officer gave his opinion, and expert opinion was again called for. That was also given. And after doing all examination and proceeding, this issue was struck off by the Honorable Court. And very interestingly, while passing the judgment by the trial court as well as the appellate court has also discussed this point, but failed to pass the concurrent decision on it. Your Honor, with regard, the Honorable Court proceeded with the evidence of PW 2, 3, and 4. PW 2 is the husband who was the manipulator of that document. PW 3 and 4 are the witnesses they have signed in that hand note. PW 3 states, yes, if Your Honor, PW 3, I only take 102 and 102 for a second. PW 3. 101, it said 101, then 103. My Lord Messi, on 102, may I read?
Yes.
PW 2. These are only the 2 witnesses. On 2/2/2014 and 11/5/2014, I, along with Senimai Soikia, that is PW 3, was present at the time of taking the money. On 2/2/2014 and 11/5/2014, no papers were made while borrowing the money. Both were present, and one stated that no papers were made on that day while borrowing the money. I take your lordship to 113, the other witness. 113. Fourth line. An agreement was made at the time when the defendant borrowed money from the plaintiff in the month of February 2014 and March 2014. I have not seen that agreement today. So, Your Honor, the case rested upon two things. One was the hand note, and the other was the witness of PW2, 3, and 4. One was the plaintiff who has not proved through income tax or any other agreement. 2, 3, and 4 are witness. 2 was the person who has admitted that, yes, I am the writer of that note. And this note was proved through an FSL expert that it was manipulated. 1 lakh is also admitted by the defendant. PW3 states that I was with PW4. And yes, I have seen the defendant taking money on these dates from plaintiff. PW3 states there was no agreement on that day. PW4 states, yes, I was with PW3. And on that day, there are 2 agreements were made on 2 dates. But those 2 agreements I have not seen on court today. So the credibility of the witnesses who are also bound by blood. And moreover, if we go to the depth, all witnesses are not corroborating to each other. The Honorable Trial Court and the Appellate Court, while discussing in detail with regard to the hand note and everything, has given its decision and passed the judgment considering the evidence of PW 1, 2, 3, and 4, and has shifted that preponderance of probability does not lie in favor of the plaintiff. The striking of the issue, which was the vital core of the case itself, was illegal and bad in law. The learned courts have discussed in detail with that aspect, but has not passed any order with that aspect. Moreover, if we go to the PW 2, 3, and 4, the witnesses also cannot be termed as credible witnesses because everyone stated differently. So, Your Honor, my submission is that this, the finding, concurrent finding, has highly prejudiced the right of the defendant. Defendant admits with regard to the 1 lakh, but complete denial with regard to the remaining 6,55,450. Okay. You know, this is my case.
Okay.
Right, legal. Here in this case, we have filed the suit for recovery of rupees 7 lakh 5,430. And we come to the page 45. This is the plain.
Page 45.
48. So it is not next really logic. In my page number 50, there is a first title of the plain. Okay, here is the basically suit filed by the exported for recovery of rupees 7,55,450. Okay. Finally, come to the page 53. That is paragraph number 13 of the plain.
Yes. Paragraph 13.
And 13 next problem. Any page, come to the page 51. That is the paragraph number 8. Okay. I'm reading the vernacular logic.
She has read, no? She has read this paragraph.
51.
She has read it.
বাদী বিবাদীৰ যথেষ্ট প্ৰতি যথেষ্ট আন্তৰিকতা মৰম ও বিশ্বাস আছিল সেয়েহে যোৱা ইংৰাজী তাৰিখে বিবাদীৰ টকাৰ প্ৰয়োজন হোৱাত সেইদিনা বিবাদী বাদী ঘৰলৈ আহে আৰু বাদীক পুনৰ 1 লাখ টকা ধাৰে দিবলৈ খাটনি ধৰে বাদীয়ে উপায় নাপাই পকী ঘৰ বনাবলৈ বুলি গোটাই থোৱা টকাৰ পৰা নগদ 1 লাখ টকা দিবলৈ ৰাজি হয় বিবাদীয়ে বাদীক অনুৰোধ কৰি কয় যে মোক যেনে তেনে Page 52 is the paragraph 9. So it was not annexed serially logic. That is why. বাদীয়ে বিবাদীক টকাখিনি ঘূৰাই দিবলৈ বহুবাৰ অনুৰোধ কৰিছিল। Page 52 logic.
Yes.
টকা কেইটা দি সহায় কৰা যেহেতু মই আগে বিভিন্ন সময়ত তোমাৰ পৰা সাক্ষীৰ সাক্ষাতত টকা লৈ আজিলৈকে আৰ্থিকভাৱে সহায় কৰি আহিছা ইয়াৰ ওপৰত ভিত্তি কৰি সাক্ষীৰ সাক্ষাত সেইদিনা এখন চুক্তিপত্ৰত বিবাদীয়ে বাদীক দিব লগা যোৱা ইংৰাজী 2/2/2014. Here 3 dates have been mentioned in the plain logic. That is
2014
Yes, yes.
for taking of rupees, amount of rupees
Yeah.
3 lakhs, and 11/5/2014 for taking of rupees 3,55,450, and 4/7/14, that is amounting rupees 1 lakh, Lordship, by executing a Lordship hand note. একেলগে ঘূৰাই দিম বুলি সাক্ষীগণৰ সাক্ষাৎ স্বাক্ষৰ গ্ৰহণ কৰি চুক্তিপত্ৰত নিজে সই কৰি এখন চুক্তিপত্ৰ সম্পাদন কৰে আৰু উক্ত মুঠ ধাৰে লোৱা টকা সেই ধাৰে লোৱা তাৰিখৰ পৰা এবছৰৰ ভিতৰত ঘূৰাই দিম বুলি চুক্তিপত্ৰত লিখিতভাৱে প্ৰতিশ্ৰুতি দিয়ে আৰু পদক্ষেপ এক হৈছে চুক্তিপত্ৰ। Thereafter, Lordship, against that, what is their defense, Lordship? As the WS is their plain, Lordship, what they have defended to our contention made in the affair, kindly come to the plain, kindly come to the page 56, Lordship. There they categorically only denied, and with regard to that paragraph, Lordship, page 57, kindly come to page 57.
Yes.
In reply to paragraph 8 of the plain, the defendant admits that the defendant took rupees 1 lakh from the plaintiff on 4/7/2014, but the defendant has denied that he had taken rupees 3 lakhs on 2/2/2014 and 3,55,000 only on 11/5/2014 from the plaintiff. It is also denied by the defendant that he had entered into an agreement to the return rupees 3 lakhs and 3,55,000 and rupees 1 lakh on 4/7/2014 within 1 year. Complete denial of it. Even also they have not said that they are liable to pay rupees 1 lakh. But subsequently they have said we are liable to pay rupees 1 lakh. That now regarding the exhibit 1, that is the hand note receipt. This paragraph number 9, what they have replied, for that contents of the document exhibit 1 appears to be fishy and manipulated one, is much as the writing appearing in the document thereon are to be of two different and duration. Here they have not elaborately mentioned which line were letter initially at which paragraph were letter subsequently. That is their defense in the WS question. Now kindly come to the that is the written statement filed by the defendant, Lordship, and defendant Lordship also examined herself as DW1. Kindly come to the page 35, Lordship. 135.
It's okay, they have admitted all this.
Yes, he admitted that she executed that document, Lordship. There was a good relation between the plaintiff and the defendant, and he used to take money, and thereafter she subsequently paid. That is because of their good relation, they take and back the money. Because of their good relation between them, Lordship. Here, your Lordship, she, Lordship, everything has stated that she doesn't know what is written in the written statement. Everything she has denied, Lordship, and subsequently said, yes, I took an amount of rupees so and so, I executed that amount so and so. The execution has been proved from the deposition of the defendant number 1 herself, Lordship. And kindly come to the Lordship, the plaintiff, before filing a suit, Lordship, send a legal notice to the defendant asking for payment of money, which they have replied, and the said legal notice they have also exhibited, exhibit 3 form. Okay? Kindly come to the page 149.
Yes.
Operative portion is paragraph 4, which they have replied to our legal notice. Okay? That my client had never been borrowed any money from the client while your client was working as an A&M nurse. After retirement of your client, my client had borrowed money from your client on 23/6/2014, an amount of rupees 10,000, on 4/7/14, an amount of rupees 1 lakh, on 27, 2014, an amount of rupees 30,000, on 4/8, 2014, an amount of rupees 50,000, or 22/8, 2014, an amount of rupees 10,000, and on 8/8, 2014, an amount of rupees 10,000. And subsequently, my client had returned to your client an amount of rupees 60,000 only out of the total amount of rupees 2,10,000. It is pertinent to mention here that by estimating an amount of rupees 7 lakh so and so, your client is totally false irregularity. Here, last line logic, line 5, paragraph number 5, that my client had promised to your client that she will return the money of rupees 1,50,000 as soon as possible. Here also, he admitted not 1 lakh, now 1,50,000. But from different states, they changed their version. One in one place, they have said that he is liable to return rupees 1 lakh, and now in the legal reply, he admitted that he is liable to return rupees 1,50,000, liable to pay also. From that also, from this document, it is discernible that there was a good relation, and he used to lend money from the plaintiff and return subsequently. Now, Lordship, to prove his case of the plaintiff, Lordship, the plaintiff examined herself as PW1 and the note written by PW2, Lordship. He has also been examined in this case. And 3 and 4 are the, Lordship, the witness present at the time of execution and who knows about the lending of money to the defendant and accepting by the defendant that amount of rupees 7,50,450. And they all in their deposition, Lordship, they extensively cross-examined by the Lordship plaintiff. They corroborate the version of the PW1, Lordship, that they were present at the time. They knows the transaction between the plaintiff and the defendant. Therefore, they corroborate the case of the plaintiff and prove that the defendant has taken an amount of rupees 7 lakh so and so. So far as the Lordship issue, striking out of issue is concerned, Lordship, as my learned friend has shown to your Lordship, as page 62, Lordship, that issue was struck off, Lordship, after hearing the both sides, Lordship. Kindly come to the page 62, Lordship, for a moment. Because defendant was also there at the time of hearing whether the said issue is a relevant issue or not, Lordship. Page 62.
Okay.
Page 62, kindly come, Lordship. While perusing the case record for preparing the judgment, it is found that the issue number 3 framed by the my learned predecessor by order dated 25/1/16 regarding validity of the agreement between the plaintiff and the defendant is not relevant material for deciding the suit. It is to be stated that though in the plain it is stated that on 2/2/2014 the defendant entered into an agreement. From the said agreement dated 2/2/14, it is seen that it is a hand note, money receipt only, and not an agreement as stated by plaintiff. Therefore, after hearing the parties, issue number 3 is struck off. After hearing the parties, the said order was passed at the instance of the Lordship defendant, Lordship. And after hearing the parties, and after striking order of striking of the issue, Lordship, has not been challenged before any court, Lordship. It is remain intact, Lordship, and attain its finality, Lordship. And now they have not raised the issue at the appellate case, Lordship. So far as, Lordship, the evidence of FSL report and evidence of official witness, Lordship, the FSL report was called for, Lordship, on the petition filed by the defendant. When it was called for, and the said examination was done, Lordship, as your Lordship know, that it was a opinion of the expert, Lordship, under section 45 of the Evidence Act. And it's not a substantive piece of evidence, Lordship. It needs corroboration to prove any fact, Lordship.
Okay.
And in the absence of, Lordship, the corroboration, Lordship, that cannot be admitted, Lordship, as evidence, Lordship. And court may or may not accept the version of the opinion of the expert. Since the plaintiff examined himself and another 3 witness corroborated case of the plaintiff has discharged her burden, Lordship, and prove his case. And on the other hand, Lordship, the defendant has failed to cast the burden lies upon her by adducing any evidence or discarded the evidence adduced by the plaintiff. And your lordship is aware today the plaintiff invoking the jurisdiction under 100 of lordship CPC, second appeal lordship. The second appeal will be decided under substantial question of law. Lordship. And substantial question lordship, there are judgment of the honorable Supreme Court. Even if there are some
Defendant did not reduce evidence.
examine herself only. And under section 100, the appellate second appeal will be decided on the substantial question of law. Lordship, even if the finding recorded by the trial court is erroneous, that is also not can entered into by exercising power under section 100. I'll raise some judgment on this point, Lordship. And this court has to my humble submission, has under section 100 is a limited jurisdiction. Substantial question always be there for interfering the judgment passed by the courts below. Lordship. And here in this case, the trial court has decreed the suit, and on appeal filed by the defendant, their appeal was dismissed, the decree was upheld, Lordship, and thereafter they have come. And whatever points they have raised in this case, Lordship, these are not substantial question of law. These are all facts, Lordship, that has already been extensively adjudicated by the trial court below, Lordship. And the finding of facts already been attained its finality, Lordship. And I'm placing some judgment, Lordship, regarding power. It is a very recent judgment, Lordship, decided on 6/3/2025. Lordship, that is why it has not been reported in the SSC, Lordship. I have taken out it from my law library, Lordship. Here the Supreme Court has held that, Lordship, the scope of second appeal, the Supreme Court reiterated that in the second appeal under section 100, the High Court is not empowered to disturb findings of fact recorded by the lower courts unless there are perverse, meaning they are based on no evidence or the conclusion drawn from the evidence are unreasonable or illogical. Lordship. Here the relevant paragraph number 6, 7, 8, 9. Here the Supreme Court has discussed the previous judgment regarding the power under article under section 100 of CPC, Lordship, by in second appeal, Lordship. Here the court below has decided the case in my favor. There is a concurrent finding, Lordship, of fact, Lordship. Despite there being the substantial question, court at this stage cannot interfere with the or disturb the views taken by the both the court below. 6, 7, and 8, 9, Lordship. I'm not repeating those results, Lordship.
Yes,
I have already.
it's mentioned here.
Next judgment, Lordship, is reported in 2019 7 SSC, page 71, paragraph number 13, 14, 15, and 16. These are the relevant paragraph, Lordship. Here also the Honorable Supreme Court reiterates by mentioning the previous citation of the Honorable High Court regarding the power of 100 in exercising under in second appeal, Lordship. 13, 14, 15, and 16, Lordship.
All right. So is there any scope for settlement?
No.
Any scope for settlement? No.
Because execution has already been started, Lordship.
Writ has already been issued during the, because we have filed a petition for early hearing for that reason. Writ has already been issued in the process, and the next date is fixed on on 20. And with regard to the, with one more submission, with regard to the concurrent finding and with regard to substantial question of law, where there are judgments, I'll place before Lordship, I'll pass. There are judgments in which when it is prejudiced the rights, it is the duty of the court to decide upon the fact whether that question of law can be framed or not. Now I'll submit two judgments with this regard. Because and one more submission is that would be pleased to, because I'll not repeat, page number 38 and 39 of the of the trial court, and page number 38 and 37 and 38, 39, and page number 23 and 24 of the learned appellate court. Both the courts 23 and 24 of the appellate court judgment, page 37, 38 and 39 of the learned trial court judgment has discussed with regard to the issue. And moreover, and one more submission is that would be pleased to produce page 140 with regard to the opinion of the expert. Because
Page
if the
number?
140, 140.
Okay. All right.
I place another judgment regarding acceptance of opinion of the expert as evidence. Here I have also mentioned the relevant paragraph. Although it is in the criminal case, but the ratio laid down by the Supreme Court is in the acceptance of the.
No.
Yes,
No.
only I will not.
45 Evidence Act.
Yes.
Our learned counsel, Miss
S.G. Burua.
S. Neo.
S.G.
S.G. Burua for the appellant, and learned counsel, Mr.
B. Haldar.
B. Haldar for the respondent, reserved for judgment and order.
Obliged to not.
Number 15 and 16.
Okay. Okay.
May it please.
I don't know whether I'll be able to take in anymore, but I'll have to hear.
The question is very small in this case.
Okay, then it is better, then I'll be able to take in.
Now, my lord, the deceased was a,
Mm.
my lord, a school teacher,
Mm.
a retired school teacher.
Mm.
Now, at the time of the accident, his age was 65 years. Now, the contention of the claimant is that
Mm.
the income he was deriving from his pensionary amount is 22,120,
Mm.
and another 10,000 from a private firm he was working.
Okay, pensionary amount was?
20, I'll take your lordship to that.
22,000.
22,128.
Okay.
And the deceased was receiving that amount.
Mm.
And ultimately, my lord, the finding of the learned judge is that claimant was also receiving that amount. Now, the 10,000 court did not believe because the certificate they produced, they could not deduce any evidence. The person
Extra
who
10,000 he was earning from.
from some private job.
Yes, after retirement.
Yes,
Which
but
people usually do
right.
nowadays.
But they could not substantiate that by bringing the witness, and therefore it was not believed. Now, the short question which call for your lordship's consideration: supposing, my lord, in motor accident cases, your lordship will find
Mm.
always the dependency loss is counted.
Mm.
Now, here the dependency loss is not there because the pensionary amount supposed to be the income of the deceased. The as family pension, my lord, the family was getting that. Now, that is the crux your lordship will see.
Mm.
If they were really getting that pensionary income, then how the learned judges computed that was a loss, and in that case, what will happen? Once the school will give the pensionary benefit of 22,122 per month, now another amount will be given by the insurance company. My lord, it may be a beneficial legislation, but then it is never contemplated that benefit will be rendered twice.
You are for the insurer?
I'm for the insurance company. Now, that is the only question, my lord, which your lordship will like to decide. I'll take your lordships to the judgment to get the fact of the case, my lord. Your lordship may come down to page 8. I'll
Page
start
8,
from,
yes.
yes, page 8, paragraph 1 onwards. I'll just read the brief factual position of the case.
This claim petition has been filed under section so and so, seeking grant of compensation to the tune of rupees 41 lakhs with interest so and so, so and so. Then para 2. The claimant's case in brief is that the fateful day on 25/3/2016 at about so and so, claimant's deceased husband, Father Sikandar Ali, was proceeding from Borpeta Road towards Howli by driving his motorcycle, bearing registration number so and so, through the left side of the road in normal speed. And when he reached near Jaswal Line Hotel, so and so, all of a sudden a speeding oil tanker bearing registration number so and so coming from same direction in a very rash and negligent manner knocked down him. As a result, claimant's husband, Father Sikandar Ali, sustained severe head injury. He was although shifted to the Borpeta and subsequently to Narayana Super Specialty Hospital, but he succumbed. Claimants have accordingly filed this case against the insurer, owner, and driver of the offending vehicle by airing them as opposite party number so and so. The claimants have also arraigned one of sons of the deceased as opposite party number 4. All the opposite parties has entered their appearance and contested the case by filing their written statements. OP number 4 has filed an affidavit stating that he has no objection if the entire awarded amount is given to the claimants. OP number 1, that is the New India Assurance Company Limited, in its written statement has denied any kind of liability for payment of compensation to claimants arising out of the alleged accident by taking all usual pleas of defense. OP number 1, although stated that its liability would be limited to the provision of section 147, 149(2) of the Motor Vehicle Act, but no specific statutory defense as provided under the provision of law has been taken by the OP number 1. OP number 2 and 3, in written statement denying the fault of the driver in the alleged accident and any kind of liability for payment of compensation to the claimant, stated that at the material point of time of the accident, the vehicular documents was valid. Then your lordship may skip to paragraph 9 at page 11. There is the decision and reason thereof. Claimant number 1 has examined herself as the sole witness PW1 in support of the claimant's case, and that she also submitted various documents for the purpose of establishing the case in their favor. The opposite party number 1 has also adduced evidence of one witness, that is DW1, in support of their case in defense. From the evidence of witnesses and the materials brought on record by the claimants, particularly the accident information report on Form Exhibit 1, coupled with the certified copies of GD entry number so and so, dated so and so of Howli PS, death summary certificate Exhibit so and so, postmortem report of deceased Sikandar Exhibit 12, death certificate Exhibit 13, and charge sheet Exhibit 17, MBI report, it becomes quite clear and evident that the alleged accident had taken place on 25/3/2016 at about 4 p.m. at Howli near Jaswal Line Hotel, Manos Kanya Dhaba, under Howli Police Station in the district of Borpeta, Assam, with the involvement of two vehicles bearing registration number so and so well tanker and registration number so and so the motorcycle. It is also revealed from the above that regarding the said accident, a police case got registered at Howli PS case number so and so. Claimants have attributed cause of accident to the rash and negligent manner of driving of the offending vehicle by its driver. Claimants have not adduced any eyewitness to the case. The documents of the police case suggest that the claimant was approaching the offending vehicle from the opposite direction. Although the relevant GD entry number so and so suggests that the deceased motorcycle had hit the rear wheel of the well tanker, there is no clarity from the materials available on record. Now, these two entries your lordship will find on record that actually the deceased who was riding his motorcycle, he hit the well tanker, and as a result, the accident took place. There is no clarity from the materials available on record about the manner in which the alleged accident had taken place. The MBI reports of the colliding vehicles are also silent with regard to the damage caused to the vehicle. As such, both the vehicles are held to be equally responsible for causing the alleged accident. Since the deceased contribution has been held to be 50%, the compensation to which the claimants are held to be entitled will be 50% of the just compensation as per the computation. Allegation about the rash and negligent manner of driving of the offending vehicle number so and so accordingly stand established to the extent of 50%. That being the case and the alleged accidental death of claimants, Sikandar Ali having been proved, the question now arises as to what would be the quantum of just and fair compensation and who would be entitled to pay the same. Claimants being the wife, son of the deceased, have raised this claim being his legal heirs and representatives. Claimant number 2 and 3, although are the major sons of the deceased, but at the relevant time they were students as revealed from exhibit so and so. All the claimants are accordingly considered as dependents of the deceased in the present case. The OP number 4, Rabil Hussain, son of the deceased, filed an affidavit stating that if the entire award is given to his mother and the other claimants, then he has no any objection. Exhibit 18, pension payment order, reveals the date of birth of the deceased as so and so. The age of the deceased on the day of accident was 64 years, 24 days. It would be as such be appropriate to take the slot of 65 to 65 years. For the purpose of selection of multiplier, these are my lord all admitted position. Now in the middle part, your lordship kindly come. The claimants have asserted from their middle. The claimants have asserted that the deceased was a pension holder and he used to earn an amount of rupees 22,128 per month as pension, and deceased also doing private service under Baghwar Bazaar Committee cum Baghwar Development Committee as a secretary, thereby drawing a salary of rupees 10,000 per month at the time of his sudden death. Claimant number 1, wife of the deceased, although produced income certificate, but the same has not been established. As such, the pension received by the deceased is considered to be his only earning. Exhibit 19 reveals that the claimant was receiving pension of rupees 22,128 as his last pension, which is accepted. Now, this is the most vital line. Now, the learned judge has accepted that exhibit 19 reveals that the claimant was receiving pension of rupees so and so.
There's one judgment.
Yes.
I do not know, Supreme Court judgment, I think, that pensioner, if dies, he will get the.
Right. Very right. Well, I'll take to your lordship that Helen Rivarius case. That has said, my lord, Provident Fund,
Provident fund cannot be deducted.
LIC, pension, because these are not pecuniary advantage to the claimant. It is automatically because if I'm having a policy, if something happens to me, at the time of maturity, automatically I will get. It is not dependent on the accident. So therefore, likewise, pension also, it is when the person, my lord, the retires at the age of superannuation, the pension they will get automatic. Now here is not a case of pension that from the award it is deducted. It's a different. The Helen Rivera's case, my lord, I will take your lordship. Your lordship has rightly reminded that. Often, my lord, the tribunals get confused with this and they come up with many wrong judgments, my lord, and therefore, my lord, we are to come before this honorable court. My lord, I'll hand over to your lordship this judgment, 1999 1 SSC. I'll take your lordship to paragraph 34 and 35. I'll read from paragraph 34. This is based on the principle that the claimant for the happening of the same incident may not gain twice from two sources. This it is excluded thus either through the wisdom of the legislature or through the principle of loss and gain, through deduction, not to give gain to the claimant twice arising from the same transaction, namely the same accident. It is significant to record here in both the sources, either under the Motor Vehicle Act or from the employer, the compensation receivable by the claimant is either statutory or through the security of the employer securing for his employee. But in both the cases, he receives the amount without his contribution. How does an amount earned out of one's labor or contribution towards one's wealth, savings, etc., either for himself or for his family, which such person knows under the law, has to go to his heirs after his death, either by succession or under a will, could be said to be the pecuniary gain, only on account of one's accidental death. This, of course, is a pecuniary gain, but how this is equitable or could be balanced out of the amount to be received as compensation under the Motor Vehicles Act. There is no correlation between the two amounts, not even remotely. How can an amount of loss and gain of one contract be made applicable to the loss and gain of another contract? Similarly, how an amount receivable under a statute has any correlation with an amount earned by an individual? Principle of loss and gain has to be on the same plane with the same sphere of force subject to the contract to the contrary or any provisions of law. Broadly, we may examine the receipt of the provident fund, which is a deferred payment out of the contribution made by an employee during the tenure of his service. Such employee or his heirs are entitled to receive this amount irrespective of accidental death. This amount is secured, is certain to be received, while the amount under the Motor Vehicles Act is uncertain and is receivable only on the happening of the event, namely accident, which may not take place at all. Similarly, family pension is also earned by an employee for the benefit of his family in the form of his contribution in the service in terms of the service conditions receivable by the heirs after his death. The heirs receive family pension even otherwise than the accidental death. No correlation between the two. Similarly, life insurance policy is received either by the insured or the heirs of the insured on account of the contract with the insurer, for which the insured contributes in the form of premium. It is receivable even by the insured if he lives till maturity after paying all the premium. In the case of death, the insurer indemnifies to pay the sum to the heirs again in terms of the contract for the premium paid. Again, this amount is receivable by the claimant not on account of any accidental death, but otherwise on the insured's death. Death is only a step or contingency in terms of the contract to receive the amount. Similarly, any cash, bank balance, shares, fixed deposits, etc., though are all a pecuniary advantage receivable by the heirs on account of one's death, but all these have no correlation with the amount receivable under a statute occasion only on amount of accidental death. How could such an amount come within the periphery of the motor vehicle accident to be termed as pecuniary advantage liable for deduction? When we seek the principle of loss and gain, it has to be on a similar and same plane having nexus interse between them and not to which there is any semblance of any correlation. The insured that is deceased contributes his own money for which he received the amount which has no correlation to the compensation computed as against the tortfeasor for his negligence on account of the accident. As aforesaid, the amount receivable as compensation under the Act is on account of injury or death without making any contribution towards it. Then how can the fruits of an amount received through contributions of the insured be deducted out of the amount receivable under the Motor Vehicles Act? The amount under this Act he receives without any contribution, as we have said, the compensation payable under the Motor Vehicle Act is statutory, while the amount receivable under the life insurance is contractual. So, my lord, here this is lordship what they have explained. Now, regarding insurance policy, and person will give premium.
Yes,
Now,
that I
it
understood.
is
Even provident fund also you.
yes, yes. It is not dependent on the accident because this is
So
natural
then,
thing.
this is not deducted.
No,
Provident fund
never,
amount is
never.
not deducted.
It is never
Even
deducted.
pension also is mentioned
In
here.
pension also it is not deducted. And here in this case, the question of deduction is not coming. Rather, it's a reverse gear. Your lordship kindly see On the death of the person, my lord, he was receiving family pension 22,128. Now, after his death, family will get, and the family is, my lord, is getting 22,128.
Yes, she'll be getting.
So where
every
is the
month.
dependency loss? Is not a question that there is an award of rupees
So if
something.
you exclude, then what does she deserve?
No, here, my lord, there is,
The legal heirs, what does they deserve?
no,
What
in
do they
this
deserve?
case, my lord, there is no dependency loss at all. Because whether they are getting this amount or not, if there is any suspicion, then
No
they,
dependency loss, but there will be other loss also.
other loss, they whatever they say, the 10,000 for from private job, that they could not, my lord, produce any evidence. They placed a certificate before the court. They did not give any evidence that person should have been called, because unless you give evidence, we are losing the chance of cross-examination. Because certificate, my lord, your lordship knows that anybody can place the certificate. So you must face the cross-examination to prove the authenticity of the certificate. So therefore, in this case, my lord, I fail to understand how learned judge, after giving this finding, again is saying that is a loss is there, and therefore has computed the income as if there is a pensionary loss of rupees 22,128. That is the only question your lordship is required to decide. In regard to the loss of pensionary income, my lord, like the LIC and all that will not come here at all. And these cannot be correlated with the accident. Because so far, my lord, insurance policy is concerned, either the person in whose name he will get, or if he dies, their legal heir will get. So it has got no correlation with the accidental death.
So here the claimant is the wife.
Claimant is the wife. So family pension, obviously, she'll be getting. And if there is any doubt, my learned friend can produce that
She'll
account.
get half.
Yes,
After his get
50%.
she'll get half.
Pension regulation. my lord.
10,000 she'll get now.
No, my lord, now as far
I know it has increased.
it will increase, my lord, gradually, because it is the net salary, basic will be there,
Hmm.
plus DA, then
It will
plus
be
NA.
added and it will go on adding and then.
Yes. Because my mother, she is also getting, my lord, pension. Now, earlier she was getting 24,000, now it is 41,000. So every year basis, my lord, DA and MA, all these things is to increase. So therefore, in this case, your lordship will find there is no loss at all, because both the things the learned judge, if your lordship kindly look at, now the finding is claimant number 1, although produced income certificate, but the same has not been established, that is over. As such, the pension received by the deceased is considered to be his only earning.
Yes.
Exhibit 19
We
reveals
have
that
read
the
it out, no?
claimant was receiving the pension. And obviously, my lord, she is a legal heir, she will receive it.
Yes.
So now, when you are getting this amount, then where is the dependency loss? So on these count, my lord, entire judgment is vitiated. Because since it's a beneficial legislation, you cannot give the benefit twice. Otherwise, your lordship kindly visualize. Here they are getting pension, and again my lord, the tribunal has passed an order to give this benefit, and now it will be a benefit twice. And the recent decision of the appeals court, my lord, I did not bring it. It has come out in 2025. That benefit cannot be given twice. So those are the judgments, my lord. If required, I'll place it before your lordship. So on this account, my lord, this entire award is vitiated because of this finding. And your
The other
lordship,
side is represented by whom?
Yes.
You have concluded, no?
Yes, I more or less contribute only, my lord. There is 2 or 3 decision. I'll place it before your lordship.
You are the insurer here. You are not the insurer
I'm
here.
for the claimant lordship. Respond number 1, 2, and
So
3.
you have changed your
Lordship.
now you have changed your place. You're for the claimant now. Okay. What do you have to say?
Lordship, first of all, here two items, Lordship. One preferred by the insurance company, that is item number 15, and other is preferred by us, that is the claimant.
Okay. So here, there are two cases here.
Similar, same case,
Oh, 15 and 16, no?
15 and 16.
One is MSC 509 and the other is
MSC
MSC
286. Yes,
Okay.
Lordship. So in our appeal, Lordship, the main ground we have taken is regarding the learned member, means he came to a conclusion that 50% contribution was made by the claimant towards the accident.
Mhm.
That is that. But Lordship, the claimant side exhibited not only the GD entry, but also the FIR, the search sheet, every other police documents, which clearly states that the search sheet also, even the offending vehicle, the oil tanker driver was search sheeted. So he was the,
So no contributory negligence.
so in our, one of our ground is there, Lordship. That is in fact main ground. So that 50% deduction should not have been there, Lordship. Then Lordship, the learned member, based on the ZD entry only, came to a conclusion that the claimant contributed towards the accident, whereas it is not at all mentioned clearly whether the accident took place due to the fault of both the vehicles or only with the oil tanker. However, after the due course of investigation by the police, it came to light that the accident was caused due to the rash and negligent driving of the oil tanker, and so accordingly the driver was arrested and the criminal case proceeded against him. So deduction of the 50% is
Your
totally
motorcycle was not
unbiased.
insured.
Our vehicle was also insured.
Insured. And it was valid also.
It was valid also.
So there's no
The
problem.
policy coverage is not in dispute, Lordship, in this case.
So
The 50% deduction was our contribution.
anybody will pay 50%, 50%, both will be paid if the judgment is upheld.
Lordship?
50%, even if you are having contributory negligence.
Yes.
Anyway, it will be paid by the insurer of
No,
the
Lordship.
vehicles.
As the learned member came to conclusion that 50% contribution was made by me, made by the deceased.
Hmm.
So that amount was deducted, Lordship. Only 50% of the award, because the learned member.
Okay, due to contributory negligence, that 50% was deducted.
Yes.
All right, I got your point. All right.
Means 14,22,380 was first considered. Later on 50% was deducted, which came to 7,11,190. So that was the amount. So, and as the claimant exhibited the search sheet, the FIR, the seizure list, every documents. So relying on the ZDNP itself is not as per law, Lordship.
And what about the pension?
And pension, Lordship, has already, my senior has already discussed about the Helen C. Rebello case. And Lordship, I would also rely on the judgment of Lordship Luna Devi. Lordship, that is a 2015 judgment where of a High Court, Lordship, however, that is not a Supreme Court. There specific mention is made regarding the pension amount, Lordship. I'll pass the copy to your Lordship.
Yes.
Here in Luna Devi case of Guwahati High Court, Lordship, the judgment of the Honorable Supreme Court in the case of Lalde and Helen C. Robello clearly shows that such amount has no nexus in connection with the compensation available in a motor accident. They are based on two different considerations, and so the Honorable Supreme Court did not find favor of deduction with any amount equal to family pension for the entitlement of the claimant in motor vehicle accident claim case. The law being settled in this regard in the aforesaid cases, the first one for determination is to untenability of such deduction decided in the affirmative. Accordingly, the learned tribunal committed error in making the deduction of family pension from the entitlement of the claimant, Lordship. This is a Guwahati High Court judgment that is passed after the Helen judgment. And Lordship, the other points in our appeal, Lordship. And Lordship, although we have exhibited the income certificate, which proved to show that the deceased was earning an extra income of rupees 10,000, Lordship. Although we could not produce any author of the same document, but we exhibited, and the insurance company did not place any objection to that income certificate, Lordship. No objection was placed. So, Lordship, and there's some judgment also, Lordship, regarding that point. 2022 Supreme Court 858 Manusha, Sri Kumar and others versus United India Insurance Co. where at least minimum wages should have been considered, Lordship.
What is the minimum wages now? Still at 3,000 or increased?
Minimum.
This will not come to now. This is before, I think this is before the amendment of the MB Act, no? This case
Before
or after?
amendment घटना पिछले
Judgment was delivered on? No.
It was prior, Lordship. And Lordship, regarding compensation for spousal consortium also, Lordship, as per Sarla Burma and Lordship Furnace City, it should have been, Lordship, at least 53,240, Lordship, as 10% increase after every 3 years. Until now, insurance company has not paid a single amount to the claimant, and this is a dead case, Lordship. So,
Consortium for the spouse. How much it should be?
Lordship, 53,240. If we
53,000?
count from 2017, Lordship, till date,
240, no? At the rate of 10%.
10%. Increase up every 3 years.
From Pune City's case, no?
Yes, Lordship. Furnace City and also even Sarla Burma also, Lordship.
Okay.
Our basic contentions are these, that 50% deduction is not at all proper, as we could prove, Lordship, by various police documents, and the driver was also suspected. So that amount should have not been deducted, Lordship.
You give
And-
me the judgments,
Yes, Lordship.
High Court judgment and Supreme Court judgment.
Judge. Lordship, I will be providing a copy of a written argument.
Okay.
for the- So Lordship, for 50%, Lordship, I am relying on Pushpa Rana and another, and also
Pushpa Rana and others, no?
Yes, Lordship, and
For
Pushnam
50% contribution.
50% contribution, Lordship. And for the minimum wage, Lordship, that is, I'm relying on Manusha Sri Kumar versus United India. And
For
also-
minimum wage,
Yes, Lordship.
Manusha,
Manusha Sri Kumar, Lordship. And Lordship, regarding the consortium part, Lordship, I am relying on Sarla Verma, Pranay Sethi, and also Lordship Nagappa.
Manusha,
Manisha Sri Kumar.
I don't think I have the judgment. Manusha. No. No.
Lordship, this is a rough copy I have regarding the Manusha, Lordship.
Hmm.
So I can provide a fair copy to the court master.
Okay.
In the course of it's a rough copy.
And then,
And for the consortium part, Lordship, I am relying on Nagappa and Sarla Burma and also Pranay Sethi.
I don't have here. Oh, I can get,
Pranay Sethi and Lordship.
you get it everywhere.
Sarla Burma, yes,
At
those are
present,
common
don't have,
judgment.
huh? Putu Hazarika is for Guwahati High Court judgment,
Putu Hazarika, Lordship, for
pension.
yes, Lordship, for the pension.
Pension, then it will be
That is after.
claimant, no?
Yes.
Claimant and paragraph.
Lordship, Putu Hazarika is not for it. Luna Devi is for the
Pension.
pension, Lordship.
Putu Hazarika is for
Putu Hazarika, Lordship.
Luna Devi. Yes, I have Luna Devi. Okay. Putu Hazarika is for
Copy to assign to Putu.
I don't know. Kosnuma Begum and others.
Gita Devi. Lordship, I am providing Pranay Sethi and Sarla Burma also.
Okay. Then this I'll send it back then.
Lordship.
There are many judgments given to me. I'll send it back then. These are not relevant,
Yes,
maybe.
Lordship.
এইখিনি ঘূৰাই দিবা এইখিনি
Hmm.
Sarla Verma for the what?
Sarla Burma, Lordship, for this one, for the consortium part, Lordship.
Okay, consortium.
Sarla Burma and both Pranay Sethi also.
I didn't get Pranay Sethi.
Lordship, I have given.
No. So, these are all for claimant, no?
Yes, Lordship.
Okay.
So based on this judgment, Lordship, the compensation should be increased. That is my humble submission.
But Leonard, senior counsel.
My lord, I'll just reply. Now, in this case, my lord, the cross objection filed by my learned friend, it will survive the moment this award survives. Now, the crux of the case is that if they are getting the pensionary amount, my lord, entire thing goes. Therefore, there is no question of, my lord, in regard to concert, giving consortium.
I'm
and
sorry
other-
to interrupt, Lordship, but this one is our appeal, Lordship, not cross objection.
All the same, my lord. Cross objection is also an appeal. If it is not cross objection, it is appeal. All the same. There is no difference in both the things. Now, the question would be, if it is an appeal also, this appeal will survive if the award survives. Now, the award will not survive once they fail to, my lord, your lordship will see there is an admitted position that the family is getting the pensionary benefit of 22,128. If you are getting it, there is no question of giving the same award once again, because you cannot get the benefit twice.
Yes.
My lord, I will give two of the decision tomorrow. I'll place it to my lord, court master. Now, on that point, my lord, your lordship will find there is no case at all. If this goes, entire thing goes.
Yes, yes, because consortium is a part of
This
the
is a part of
dependency.
the award.
Award.
Now, if the award is not surviving, all these peripheria will not come here. So that is the thing, and these are, your lordship will find, I have marked in the record also, the exhibit, where is that? Yes, my lord, your lordship will see exhibit 18 and 19. That is on record. The pension payment order is 18. I have marked in the record, my lord. And exhibit 19 is the bank that they have shown the last drawn pension is 22,128. And then again, my lord, it has been interpreted in page 94 in exhibit 19. In the event of death of the pensioner, family pension be paid to Srimati Rahima Khatun as a claimant in that appeal. Now, if this is the position, my lord, they are already getting this pension amount, exactly 22,128. Sometimes, my lord, what happens?
No, they will not get, he was getting 22,000. She will get 10,000.
No, 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 no. 10,000, then they will have to, then where is the evidence there? My lord, the finding of the judge is that they are getting this
He
amount.
was getting, when he was alive, he was getting.
No, no, in order to
Widow
show
gets
that,
half.
no, no, my lord, I will request one thing. Whatever they are getting now, let them place the SBI account. Let's see what, because they are not saying in the trial court also, they did not say how much they are
Actually,
getting.
dependent gets half. Half of
Lordship-
the pension received by
No,
the
your lordship is very correct.
retiree.
My lord, if I take to your lordship pension regulation, your lordship is right, but that amount, the same amount up to the age of 67, they will get it. Your lordship may see pension regulation 141
Yes,
and
yes, after the age of 67.
142.
Yes, thereafter it will be reduced a little bit.
Then after 67, it will reduce to 30%, not 50%. Now, those are the things, how much they are getting, let them place the SBI account. There's no problem, my lord. Then your lordship can come to the conclusion. Then what will happen? Supposing they are getting lesser than 22,128, say supposing, for instance, it's an hypothetical the fact I'm saying. Say in place of 22,000, they are getting 15,000. Then what is the dependency loss? 7,000. Now that 7,000 is the dependency loss. Assessment will have to be done in that manner. Alone, merely because you are a beneficiary and your husband died, the beneficial legislation has not said that you will get extra.
It must not be a windfall.
It can't be, my lord. There are so many decisions that it's not because the death will, somebody's death will not give you a very good luck for some other reason. Because death is inevitable for everybody. Someone may be out of accident. But then, so for giving of the maintenance, my lord, we are not saying that whatever they are entitled, they must get it. And I personally, I never object to all this. But that will be legally determined. Now here you are entitled to get, if there is a loss of that, my lord, I voluntarily, I will say that yes, that should be calculated in that manner. So let them place the, my lord, your lordship fix a date. In the meantime, let them produce that account. Your lordship can see that if there is any loss.
Yeah, can be fixed.
Because
If you
for
want
the,
to, but if you don't want to, it's okay. or we'll close it for judgment and order. It's up to them.
So question is, my lord, I want to make an adjudication in proper way. If there is any loss, they will get it. And I will admit to that effect, my lord. So let us be true to our position.
Yes, can be settled also.
Yes, it
amicably.
can be settled here. Otherwise, it will, whatever they are incurring any loss, your lordship will have to send it to the trial court for again, for
Yes,
another
yes.
2-3 years it will
What do you
take.
say? You want to settle it here, over here, or
Lordship, we can
I'll pass
provide
the
the,
judgment?
we can provide the bank statement, Lordship.
We'll fix it for another date then.
Short date may be given, Lordship.
Yes, yes,
As
yes.
partnered. Fix
Yes.
it as partnered, and if I won't be there,
Only
then I'll
that-
release it. then.
Right, right. That is the
Or
authentic.
Lordship may reserve it for judgment. In the meanwhile, we'll be producing
My lord,
the.
I don't know why this piecemeal system. If you produce the State Bank of accounts, all these things will be clear. We all can see it. We can assist your
He's
lordship.
free to settle it amicably, then why not?
And we will assist it, my lord. It's not that it is not like adversary
They'll make a
litigation.
calculation and maybe there will be a bargain and you can settle, or you want a judgment. It's up to you.
Lordship may fix a date. In the meanwhile, I'll be
Okay.
trying to. place
I'll
it
not
for you,
keep it as partnered, but I'll fix the date.
And I am assuring your lordship, my lord, after seeing the account, if they are to get anything, we shall help your lordship.
Yes. See,
Lordship may keep it part-heard kindly, Lordship.
partnered?
That will be my prayer.
Okay. Till then, I'll keep it as partnered because keeping prolonging is also no point.
Because Lordship, the matter, our submissions have already been finished.
Yes,
Only
yes,
this, that point.
Yes, yes. True enough.
Then is a very one small point, my lord. The moment they produce the account, it can be settled.
Yes, yes. Heard learned senior counsel Mr. S. Dutta and learned counsel Mr.
SP Sharma, Lordship.
S.K. Sharma.
SP
SP Sharma. Post up. It is submitted that a bank statement may be produced relating to the pension received by the claimant. She's surviving.
Claimant number 1, Lordship.
Claimant number 1. List the matter on hard arguments में लिखी थी वहाँ. Hard arguments by learned.
Lordship, 27, my senior has some difficulty.
Except 27 and 28
बेलके बेलके तो दिन दे दिया. 27, 28 बात थी.
Monday they were paying. 29. 29 होगा.
My lord, if your lordship reflect the account number, SBI Bank Borpeta न हो जाए. Borpeta account number, my lord, I will give to the court master account number. Account number
এইটো একদম হেৰিখন 15 item number 15 টো দি দিবা. Argument খিনি একে কেছৰে হয়. এইটো কি?
account number.
Huh?
Oh,
It's an argument.
Lordship, part-heard, Lordship.
Yes, yes. Hard. I have written hard. Part hard लिखी थी.
Obliged.
Obliged.
Another argument I cannot take in. I am oversaturated with three arguments. If you want to submit, you can submit, but I don't know whether I'll be able to absorb.
It's a very simple and
Very simple case,
Very
Lordship.
If it is very simple, then maybe I don't.
I beg your lordship indulgence. In this case, we are paying for the appellant, even the claimant. Here, my wife and my mother, my wife and my mother, two claimants are there, two appellants are there. She been not only the housewife, but the deceased, I'm talking about the deceased, she's not only the housewife, beside being a housewife, she was also working woman. She was working in a water packaging factory. But unfortunately, with the manifested error of the facts, my lordship may kindly say the part of the judgment is the internal page 21. Is the page 21, internal page 10 of the judgment.
Page 21, yes.
Page 21. I'm just reading out the 23 paragraph, 23 paragraph. Because the above law clearly laid down The housewife is also entitled to get compensation for rendering selfless service to domestic household and to society as a whole after considering the living standard and prevailing situation in 2018. It is held that income of the deceased woman is 5,000 per month. Here, I beg your lordship consideration in two
You're for,
aspects.
insurance?
I am for the claimant. So
Claimant.
it is for the enhancement.
We are for insurance.
It is for the enhancement of the judgment or the award. So what I beg your lordship considerations in two aspects. One is that it's very sorry to say that we again and again we have to come before the court to quantify the unfathomed service that rendered by a wife in terms of money. That is how much she should have, how much that have to be quantified in proper sense. That gratuitous service that renders by a housewife. And second is that the court has totally failed to consider that beside being a housewife can also be a working woman. That remained completely silent and not appreciated, even the least of it. So I'm coming to this point. I'm coming to the first point, that how to quantify and what should be the
There's a DB judgment of this court.
no, there's a lot of, no, I'm not talking about the judgments. I'm just first going to I'm just to the bedrock of the entire situation. I'm going to the because for the Supreme Court, how the Supreme Court had decided. So that is a very well known, everybody knows it was. So that is a very important, it will be primary. That is a very landmark judgment, and that is the bedrock of the judgment. So I'm coming to this judgment. It is in the year 2001. That means about more than 2 decades ago judgment. I'm coming to the first part of the judgment where it is the tort. First page is a tort compensation. Death of a housewife in accident. Annual contribution estimation in case of housewife aged 34 to 59 years were active in life, and the annual contribution would have been 36,000. That means it comes to 3,000 and is way back in the year 2011. That is 2 decades, 20 years ago judgment, when this service, gratuitous service of the housewife has been taken as a 3,000, and now it is after 2 decades, 20,000. Still, the court has taken in a lower tier. It's taken as a 5,000. So this is not only I will call that misinterpretation, as a manifested error of the fact. So I am coming again to the another judgment, that is security and another.
This, which is the relevant paragraph?
Here's a relevant paragraph. I just want to stick.
No, this is Lata Vadha's case, which is the relevant paragraph.
Relevant paragraph. So my lordship may kindly see paragraph number 10. Paragraph number 10 already details has been given. Paragraph number 10, page number 210. I'm just reading off for the paragraph of 10. So far as deceased housewives are concerned, in the absence of any data, as the housewives are not earning any income, attempts has been made to determine the compensation on the basis of service rendered by them to the house. On the basis of the age group of the housewives, appropriate multiplier has been applied. But the estimation of the value of the services rendered to the housewife, by the housewife, which has been arrived at 12,000 per annum in case of rupees 10,000 for others. That is way back in the 2000. That is more than 20, that is 25 years ago. Appears to be usually grossly low. It is true that the claimants who ought to have given the data for defining compensation did not assist in manner provided. But even in the absence of such data, taking into consideration of the multifarious service rendered by the housewife for managing the entire family, even the modest estimation should be 3,000 per month and rupees 36,000 per month. This would apply to all the housewives between the age group of 34 to 59. Admittedly, my wife is in between the age group 34 to 59. And as such, we're active in life. So this is the most important portion. Again,
Only for enhancement.
So it is for enhancement. So
You are agreeing
so
for
it is
enhancement.
considering for two things. One is that they have failed to take, even my lordship, it is very admitted fact that my lordship may kindly see what is given in Exhibit 4 of the lower court record. It is said that she was working not only as a housewife, but as an employee, where we have filed the certificates that she was working as a packaging in a bottle packaging company, and there's no any contradiction, and there's no any contradiction in the cross-examination of that of the claimant also there. So it is admittedly she was working beside being a housewife. Now it's things that has to be taken in a very observant that a housewife cannot be it envisages that housewife cannot be a working woman. That nothing has been mentioned about the working woman, and only her part of the housewife has been taken, and that has also been taken in a very low tier. A housewife died 5,000 is with all my due respect, with the greatest respect to this honorable court, is that this is disregard, this is belittle the dignity of a housewife, because in many of the cases where it has been stated that even if we take the amount that is wage, minimum wage of a daily wage, that if we take all those things, even a skilled labor, that will belittle the dignity of a woman. We can't even compare the amount of the fathoms of work he renders to a family. Cannot even we compare with even a maneuvered wages also, skilled laborers also, if we compare. So it is much vast. After 25 years, if from 3,000, we just hike it into 5,000, I think it is not at all reasonable, but it is also really belittle the entire, what I call this, dignity of a woman, of a mother, which cannot be measured by, of course, it cannot be measured by the quantum, by money, in terms of money. But another aspect which I deserve that my lordship should consider, that what happened to my work. I have been working there. I'm beside being a housewife, why my other side, that I was also a employee. That has also been court completely remained silent there. The court hasn't mentioned anything. So I deserve legally, lawfully, that my amount should be hiked. Otherwise, it will be completely attained to the entire society. And we are not living in a misogynist sort of measure. And everything has to be counted, because when these are all the guesswork. Another thing is that whenever we talk about whenever we determine, evaluate that quantum of household, guesswork is important. Well, talking about the guesswork, we have to understand the elements of the society. We talk about the assembly society. Many things have been counted in like that. Nothing can be a straight jacket. The Supreme Court, with all due respect, has to be taken.
You must stick to your appeal memo.
I'm appeal memo. I'm talking about the grounds only. Grounds two.
But you are going somewhere.
Lies. So two grounds need to be considered. That I was a working woman. That part has completely remained silent. We have given ample evidence there without any contradiction. Nothing has been mentioned about my working part. Only as a housewife has been given. But I believe it's not a belief what Supreme Court has said. It's real interpretation of the Supreme. It in fact destroys the edifice of a housewife, where it has been given only 5,000.
That much I understand.
5,000. So it's a very clear and very simple case where her housewife deserves. So I do not need that I should go for much any citations or something. It is a fact of the society, and it's very sad whenever we come. Yeah, no, it's very sad whenever we again come to quantify. Even my honorable court will find that if I given that even I go for that, which may not be a part of this Supreme Court. Even United Nations has also said a lot about for this.
I told you can be a voice for women, women's rights. Yes.
So another aspect, just another more this. Here's the last one.
5,000. What was the only 5,000?
So there's the other
So
one.
you
There's
are very
another.
agreed by the amount 5,000.
Agreed by the because of two reasons are there. Two grounds are there. This is the one of the another bedrock judgment where everything has been defined, and even it has been suggested to the Supreme Court and Apricot that please define something, give a definition of this quantum.
Paragraph?
It's in the last of the paragraph. It is given there. Last of the judgment. I put that. I'm just reading out. for the reform aforesaid, I'm just reading out paragraph last part of the 65. For the reasons aforesaid, while agreeing with the views of the brothers, humbly added, time has come for the parliament to have a rethinking for properly assessing the value of the homemakers. But sir, unfortunately,
Okay,
it has
paragraph 65.
65. Everybody has said that there has been a discrimination, but for the reason better known, it has never been evaluated in a proper sense.
All right. Insurer?
Yes.
Okay.
My lord,
Mm.
with due respect to the submission of my learned friend or the appellant, I like to, first of all, I like to contradict in one point that judgment is silent about other profession. Page 19 of their memo of appeal, page 8 of the judgment, paragraph 18, the learned tribunal is saying, in this case, the claimants have failed to prove the occupation and income of the deceased by examining any witness. Hence, the income shown by the claimants cannot be taken into consideration as the occupation is remained to be proved. Therefore, the deceased is considered to be a housewife. So the submission my learned friend has given that she was doing something, but he has submitted
No,
some.
but now he is sticking to housewife only. Is that that
But
amount he is aggrieved about the
That point I am coming here, my lord. That point I am coming. So this particular point that she was doing something else,
No, that is
apart
not
from being a
required.
housewife, has been demolished in para 18 of the
It's
judgment.
not required now because he is sticking to housewife only.
Okay. Now when the question of housewife comes, I remember my poor mother, whose contribution is invaluable when we are talking about quantifying the contribution of a housewife to a family. It cannot be quantified by monetary measure, but for compensation, we will have to arrive at something, some precedents, some trends, some practice of the honorable courts, and then only it is possible. Emotionally, it is invaluable, the contribution of a mother. So I would like to rely some judgments where, because we are doing one thing. This particular accident occurred in 2017, and today, standing in 2025, we are expecting the recent judgment which Supreme Court has passed yesterday, day before yesterday, the quantum, but it has to be considered going back to that time, 2017, when the laws occurred. We will have to consider that. So I would like to rely on these judgments, my lord, where Supreme Court at that time and many other high courts relied on the income of housewife as 3,000, 4,500, 5,000, and in one case it is 6,000. That is the plethora of judgment. Their honorable high courts and Supreme Court even assessed that this is the quantum should be considered.
Okay.
Without going into emotions. Now here in this case, this is the question of notional income, my lord. Multiplier is okay. Future prospect given in this particular case, whereas interest on future prospect has not been deducted. It is included. We are not agitating because we have not filed appeal. We have not challenged that because it is not that a big figure. But future prospect, interest on future prospect to be deducted. Honorable Guwahati High Court has passed judgment that no interest should be on the future prospect. Deduction for personal expenses, these things all are okay. Only thing, what should be the notional income of housewife? Now the question of housewife, my lord. Housewife, in what type of house? What is the financial background of that house? That has to be considered. So that type of evidence has not been led by the claimant before the court, that otherwise their family is like this, and after the accident the situation has become like this. So every family has got different financial status, different social status, different respect, commanding this different respect in the society. So all families, all housewives should not be clubbed together for getting compensation. Otherwise, Honorable FX Court would have given one straightway jacket that this should be considered for all housewives.
So I just want to add, Your Worship, the minimum wage for a form of even the farm labor set by 2070, when expired, it was 300 per day. Of a farm labor in the year 2007.
Compensation Act. And
Yeah,
according to Employee
daily wage, yeah.
Compensation Act.
As the minimum wage for a farm labor set by the government is an amendment that time, 2070 was 300 rupees 300 per days. It is for minimum for the farm laborers. So
Okay. I will also.
My lord, when somebody is not going for a daily wage
No,
work,
that, there.
why this
notional
minimum
income
wage
is-
should come?
Notional income
It
is according to the minimum wage.
National
Notional
income for minimum wage, my lord, suppose for mason, for carpenter, for somebody who is going but unable to prove. Housewife is not going anywhere. Why we are now demeaning the housewife? We have shown respect that she is invaluable, and now we are telling that labor.
it is not like that. I have said that.
Like that only.
It was never like that. It was said that even
for the
even
labor,
it has been said
my
that
lord,
if
not
we
for housewives.
if we
So respectable housewives, minimum wage should not be the criteria.
minimum wage shouldn't be
It may be
there.
more, it may be
It
less.
should be more. It has been
It
said
may
that
be more or it may be less, but it should not be compared with minimum wages.
it is
Because it is for
All right,
laborers,
all right.
and housewives should not be demeaned as
All right,
laborers.
right. Our learned counsel, Mr.
R. Goswami.
R. Goswami for the appellate and learned counsel, Mr.
A.N. Das
A.N.
for
Das
respondent number 2,
for the
insurance company.
respondent number 2. Reserved for judgment and order.
Deeply aware.
Hearing?
Yes. Other side is outside, Your Lordship.
Will I be able to hear?
Lordship,
I heard 4 cases back to back.
Lordship, actually,
If ever I hear also, will I be able to absorb? I don't know.
Lordship can do the hearing on stay only. Because there is a stay of execution.
The other side.
If I may submit, Lordship, this case is
On
decreed.
stay.
Yes,
I
yes,
I on stay.
there is an order, Lordship, order dated 24 to 2025.
You want to vacate the stay?
Yes.
You'll be able to submit, or your senior has to
My
come?
senior coming.
Okay, your senior is on his way. Okay, you can start.
Yes. Lordship, this case was decided and decreed based on the admission. And judgment was passed under order 12 rule 6. So Lordship, if your Lordship, I also marked in the LCR, the flag mark. If your Lordship will look at their written statement, which they have also annexed here,
Where is the IA for stay? What is the number?
IA number, Lordship, 33. 3442. 3442, no? 3742, sorry, Lordship.
Okay,
3742.
This is the IA to vacate the stay order.
Yes.
When, in which IA was the stay order passed?
This 3742, Lordship, the order was passed on 24 to 2025.
Okay, okay, in this, this
Till
IA.
returnable date, the execution proceeding was stayed. And the LCR was received.
There's no order.
There is an order, Lordship, 24 to 20.
I 3742, there is no order for stay.
There is an order, Lordship. 3742 order এটা আপনার stay আছে till returnable date.
3742? না এটা 3742 হয় হ্যাঁ তাদের order নাই order.
The execution was stayed, Lordship.
এটা delay condemnation হয় Who order?
The order of Justice P. Swikia.
There's no order, I'm sorry. There's no order of stay in IS 3742.
P. Swikia, Justice P. Swikia, 24 to 2025. আরে আপনার RFA IA টা আছে IA civil 3742 2025.
When was the order passed for stay to RS?
24 to 2025.
24 to. Oh, stay. Okay, we got it. He wants the stay to be vacated.
How? He not filed any petition.
Yes,
Lord,
And-
we have
and-
filed our petition.
And the entire petition, if there's order, entire matter will be heard and disposed of. There is order.
Lordship, we are ready. We are ready to.
We are ready, we are also ready. How can he make a period that?
Oh, you will.
I'm
have to-
ready.
How long will you take?
Sometime is required, half an hour, more than half an hour.
More than half an hour, we don't have.
Then next, any day, I am
No,
ready.
Lordship, this
I am
is-
ready.
this is
How,
not done.
how
On
the,
previous occasion also, this
no, my
time.
lord, it is not a
This is
fact.
not-
This is the order, my lord. The lordship kindly see, this is the order, there is the order.
Lordship, they.
This honorable court fix the matter for final disposal.
Lordship can simply see the written statement they have
Then it is
submitted.
another matter. It is another matter. I want to.
No, no,
argue. I want to
IA,
argue.
they take the
Then
ground
it-
in IA that there is an additional evidence. Lordship, the question of additional evidence will arise only when.
It is hearing will, after
The
hearing, it
question
will
of
be decided, my
additional
lord.
evidence will arise
After
only
hearing,
when there is.
without hearing, my
there
lord,
is-
my lord, the learned court below what happened, my lord.
Lordship,
Without
and-
hearing us, without finding any issue, my
and-
lord, summarily this is.
Lordship, this is not the way.
allowed
Let me
petition,
submit,
my lord.
Lordship. This
I am
is-
the petitioner, my lord, I am the
Lordship,
petitioner.
and the.
I am the
and-
petitioner, he will get
And
a chance to
execution
argue.
was partly allowed, Lordship, partly executed. These performer defendants, their deed of agreement and their power of
Hello, he
attorney
is
has
the
already been.
respondent, I am the petitioner. I have the right to argue first, then he gets a chance.
Let him argue.
Yes,
I am ready.
then why you are jumping?
In your absence,
My
I'm
lord,
just
no, no,
submitting.
no. No, you
See,
now I come, you take it.
See,
Okay.
I won't be.
No, no,
able to
I am
take
no,
on
I have no
hearing.
problem. Next day, is a Monday, Tuesday, is a fixed mail. I have no problem.
Lordship, I fix it on Monday.
Monday, okay.
Monday.
Well, I have no objection, but he
You-
come and say, to
Monday,
make it without filing petition.
Due to paucity of type, I am
Well.
putting it on me.
Monday,
Due to paucity of type, please the matter on Tuesday.
20 May. I'm obliged.
So back to back, I've been
Yes,
hearing
my lord.
4 cases.
My lord, it is not a case that he come and say, vacate the Indian matter. What is this?
No, Lordship, if he
What
is
is
here,
this?
then we are ready because stay
Why
stay was granted.
This is
to
not the way,
Chandrapur
my lord.
Lordship,
This
and
is
there
not
is
the way.
no ground.
Hello.
Obliged.